hood pinning the items against the windshield, as well as that wiper arm.
Okay. Did you eventually remove these items?
Yes.
What did you find them to be?
It was a detachable hood from a jacket as well as a winter hat.
And can you just point out on the touch screen which is which?
Objection leading.
Overruled.
That's the hood portion, and that's the hat portion.
Okay, thank you. Did you find any U.S. mail or paperwork inside the vehicle?
Objection relevancy.
Overruled. The witness may answer.
Yes, I did.
Hey
Were
guys,
there any names
we're just gonna
associated
start
with the U.S. mail
watching
or
it
paperwork
live.
inside the vehicle?
Objection relevancy.
Overruled. The witness may answer.
Yes.
What was that name?
Daryl E. Brooks, Jr.
Was there an address, if you can recall?
Objection relevancy.
Overruled. The witness may answer.
There was, but I don't exactly recall it.
Sure. Also on the table next to you, sir, is your report that I've marked as exhibit number 90. Do you see that?
Yes.
Wait. Placed on the table.
Go ahead, Attorney Opper.
Well, objection. How did it get on the table?
Your objections noted. It's overruled.
What's he objecting to?
Record will reflect that there's a copy of a crime lab report. It has an exhibit sticker, number 90, with the case number of this case. Handing it back to the witness. Go ahead, you may question.
How did it get on the table? Who placed it on the table?
Attorney
that's
Opper
the objection.
indicated she placed it there.
When did that happen?
Attorney Opper, go ahead, continue.
Probably
Did you
this
author
morning.
this report, sir?
Yes, I did.
If you review the report, would you be able to see the address for Daryl Brooks that was noted in the paperwork from the inside of the SUV?
I will.
Objection. I don't consent to being called that name.
Please
Noted.
do.
Overruled.
Yes, I would.
Please do that, sir.
Objection.
Overruled.
Grounds for the overrule.
The witness may answer.
Grounds for the overrule.
Go ahead, sir.
The address for the pieces of mail that I recovered was 4014 North 19th Street, Milwaukee, Wisconsin, 53209.
Thank you.
Objection. That should be strike. When he asked the question, he said he didn't recall. So how can you force somebody to recall?
The witness's recollection was refreshed through the use of his report, which he indicated he documented the address.
Yep.
Your objections noted. It's overruled.
Exception to the hearsay rule allows him to review those
Actually, if
photos
I
or
could
reports to refresh his
back up
recollection.
1 minute and ask Ms. Gussie to put back up 117. Got to ask a question about 117.
Go ahead.
And if we could display it,
get to do
please,
what y'all
Madam
wanna
Clerk.
Nobody got to answer no questions.
Mr. Brooks, please
He's-
refrain from interrupting. You'll have an opportunity to ask.
Still doing the
questions.
commentary.
How stuff got to the table without my knowledge, that should be known. That should at least be noted for the record.
It was
I wouldn't
noted
be.
for-
I wouldn't be able to do that.
Your objections noted. It's overruled. Go ahead, Attorney Opper.
We probably could
It needs to
if
stop
he.
happening.
In
It needs
addition
be
to the
fixed.
hat,
Oh, he's mad.
Excuse the jury.
Yep, there we go. All right, here we go. Once again.
Stuff without should be a fair trial. That's my right. You shouldn't be able to do things without my knowledge. And then pass it off to the jury like that's fair.
He's getting away with a lot more than most lawyers. I mean, Danny, to ask to tell you directly, if a lawyer was doing this, they would be sanctioned. Not only placing contempt, it's sanctioned, probably referred to the disciplinary committee. So yeah, and now he's throwing a tantrum.
Since the jury's out, I'll make a record. All right, Mr. Brooks, you are well aware that the reason
consent to being
documents
called that
are
name.
being put on the
I don't consent to
witness
being
stand
called that name.
are because this court indicated it would limit the movement of the parties due to your custodial status to keep things fair.
And I
You are
merely asked, how
attempting-
did it get there?
Sir, do not
I'm
interrupt me, or you will
I'm not
forfeit your
entitled
right
to
to be
know how I got
present
there.
in this courtroom.
So
Do
you
not
holding me in
interrupt
contempt?
me.
Are you holding me in contempt?
Oh my God.
I'm gonna make a record.
Are you holding me in contempt?
I'm not answering your questions.
So then you're not holding me in contempt.
Do not interrupt me again, or you will go to the other courtroom.
Under what lawful law?
All right, he's interrupted me.
And there we go.
We're gonna clear the courtroom.
And we're gone.
He's being disrespectful. I'll make a record once he moves. Unless you can promise me right now that you let me make my record without you interrupting me, sir.
You gonna make your record? You can make your record.
Then please don't interrupt me.
Don't hold me in contempt.
I've never said any such thing.
Removing me from the courtroom, Your Honor, is essentially holding me in contempt.
All right. No, you're forfeiting your right to be present under Illinois versus Allen.
I didn't forfeit
I'm
anything.
going to start talking, and if he interrupts, then I will close this courtroom, and he will be taken to the next courtroom. Mr. Brooks, you are well aware that the court made some pretrial rulings related to whether there would be, they can stay in, I haven't closed it yet, he's not interrupting me, whether the parties could approach the witness stand. And I did that because you're in custody, and I'm not going to allow you to approach the witness stand while in custody. That is why various precautions have taken place to limit, frankly, that from happening. Throughout this trial, there was one instance at the very beginning of the case where I allowed the state to approach a witness. I corrected that. That hasn't happened since. We've had bailiffs take items up to the witness stand, or the items have been given to the witnesses, or they've been placed on the witness stand. That's proper. There is nothing wrong about that. Nobody's trying to pull a fast one over you. No one is doing something that's not permitted by this court, or frankly under the rules of decorum and courtesy or the presentation of evidence in this case. Frankly, from my perspective, sir, your attempts and your comments are to try to dig in at this jury and to somehow create doubt about the presentation of this case or the fairness of these proceedings. Without the party, meaning the state, having an opportunity to refute, explain, or correct it. I've taken the jury out at this point to admonish you that any further mumbling under your breath or not recognizing when I uphold or sustain an objection, that I will take as a disrupting interruption meant to disrupt the proceedings. I'm not holding you in contempt. I'm well aware that that's one of my options. I choose not to do it for the reasons that I've stated on the record previously. All right, you can forfeit your right to be present at any point in time during this trial by your conduct under Illinois versus Allen. When it is disruptive, when it does not follow the simple rules of courtesy and decorum, I draw your attention once again.
Come on, interrupt. Do it.
Chapter 62.
You know you want to.
Which has been previously provided to you, which is under the statute there. These constant mumbling and interruptions during the proceedings. I haven't made a record of them today, but I will now. Started at 9:01, then there was 5 at 9:02, 3 at 9:03, 4 at 9:04.
She's been keeping tabs.
2 at 9:05.
It ain't like she's not hearing this.
3 at 9:08, again at 9:17, 9:27, 10:31, 1:05.
Thank you, Jen T, for the $6.90 tip.
5 interruptions at 2:14, 2:15, 2:17, at 2:19. Audible muttering, 2:31, 2:33, what I would describe as inappropriate, like muttering under your breath, 2:35. At 3:06, there was a hilarious comment. At 3:11, there was what I would describe as arguing about the muttering and the irony of it all. At 3:12, there were 4 interruptions. At 3:37,
damn.
More 4:09, 4:10, more.
Every single one.
Twice, and at 4:12, 9.
Hey, you're right, hey, Gary. You beat me to it.
So,
She's having the
disruptions.
Oh my God, my gain is like terrible. What the hell? I'm sorry, guys.
With you,
She's had the court reporter timestamp every single time he's muttered under his
I
breath.
tell these things to the jury about how to disregard, and I simply say the jury is to disregard.
I think, Danny, you mentioned that too, and you're right.
Or the lawyers, as those are not.
Court reporter has to mark every time he says something as well.
Interrupt again if this jury comes back or when they come back and you do that, then you will be removed and you will forfeit your right to be present for the examination of this witness. Let's bring the jury back in.
Well, you might as well remove me then, because what you're doing is not fair. I can't even rebut what you're saying. I didn't interrupt you. I let you make your incorrect record.
Mr. Brooks, I'm bringing the jury out and we're continuing. We're going to get through these witnesses. Okay?
And I'm not stopping you from
Through
doing
your
that.
behavior, you're not going to delay these proceedings today.
I'm not trying to delay the
continue.
proceedings, so I wish you would stop being incorrect on the record and saying what I'm trying to do if you don't know that.
Okay,
you don't
raise.
know what I'm
I'm
trying to
bringing
do.
the jury out. I'm not going to argue with you.
Then don't. Because I'm not arguing with you either. I'm stating
You're
facts.
raising your voice.
Because I'm tired of you always
and
making a
yelling
record.
at me.
You're making a record of me trying to look bad. I know what you're trying to do. It's not going to work.
I'm
The only
making a
person who's
record of what's
making-
accurately
You're
being
making
done
a
in
record
The
of
only person who's making you look bad is
That's
you.
what you're doing. You're not making a record of
Mr.
not
Brooks,
being
I'm advising you to be quiet because the jury's coming back out.
You're advising me to be quiet? Is you telling
I'm
me to be
advising
quiet?
you to be respectful when the
Are
jury
you
comes
telling
out.
me to be quiet, or are you asking me?
I'm asking you and advising
Okay.
you.
Thank you for correcting that, because don't nobody tell me what to do. I don't tell nobody else what to do.
I'd appreciate
We're all
if you
we're
lower
all
your tone
adults
of
in here.
voice
I've
and
never
not yell at
told
me,
you to
sir.
do anything at
Set
all.
him out.
Look,
Set-
sir,
come-
I'd appreciate if your tone of voice would change.
I
Judge,
would appreciate
please
if you
send him
asked me.
out.
I'm a grown man with grown kids. Ain't nobody gonna talk to me like that. Nobody.
Oh, send him out. Please,
I
Judge.
don't have a problem with doing what you ask me to do, not tell me.
Send him out.
Just like when I asked you about subject matter jurisdiction that you have yet to prove on the record. But somehow I'm being intentionally disruptive. Come on, man. Stop. Just stop it.
Jury's coming out.
All rise for the jury.
Not gonna work.
Man, that's. Danny, you're right. He is such an abuser. That was his abuser mode turned on, in my opinion. This can't be shown to show that he's incompetent. This is going to show that he prejudiced himself throughout this entire trial. I mean, the judge is not going to issue contempt because it's meaningless. Contempt would only further delay the proceedings, which is exactly what he wants.
Thank you, everyone. Please be seated. Statement continue its examination of this witness. I believe we're on Exhibit 117.
Yes, we had 117. Madam Clerk, would you please turn the display back on? Mr. Johnson, were there other items on the front passenger seat besides the blue winter hat?
Objection leading.
Overruled. The witness may answer.
I do recall a cell phone being present on that front passenger seat.
Do you remember what kind of cell phone?
An iPhone.
I also see some items that look like maybe headphones or charging
Justin.
cable, something like that. Do you see that,
Objection
sir?
leading.
Overruled. Foundational. The witness may answer. The exhibits previously been received.
Objection speculative.
Overruled.
I do see that.
Do you remember something like that on the front passenger seat?
Yes.
Okay. And how about on the floorboard of the front passenger seat? Is there an item there, sir?
Objection leading.
Overruled. You may answer.
Yes.
What do you remember that item was?
A TV.
Okay. And to the left of the TV, the white colored object?
I don't recall what that is.
Okay. But this is the exact way the passenger seat looked when you recovered the vehicle, correct?
Looks like a busted ass TV and a Roku attached.
Now, if we could please go to Exhibit 116 and put up for the witness only.
Thank you, philosopher, for the $2. I have not seen that. I didn't even know that was a thing.
Sir, do you see Exhibit 116 in front of you?
I do.
He's been mean mugging the
Recognize his
judge
photograph.
for like the last 5 minutes.
Do you believe this to be a true and accurate depiction of the interior of the SUV?
Yes.
Move to admit 116, permission to publish.
Objection. Relevancy.
Overruled. Exhibit 116 is received. Permission to publish is granted.
No, Abby. The appellate division would likely get a transcript and or an audio recording of the proceedings.
This is
They
an
wouldn't
overview
get
of
like the
rear
TV
passenger
footage.
seat. That rear passenger compartment contained several clothing items, and
Thank you, Kit. 190 for the $2 super chat.
And was the condition of the back seat like this when you found the vehicle, sir?
Objection. Speculative.
Overruled. The witness may answer based upon his knowledge of recovering the vehicle from the scene and his training and experience.
yes.
Now for the witness only, I'm going to please ask Ms. Gussie to put up 113, 114, and 115 for his review.
Go ahead.
113 up?
Yes,
Okay, do you recognize that item?
I do.
Okay. Next, 114. Do you recognize 114?
Yes,
And 115, do you recognize 115? There it is.
I do.
Okay. Do you believe these three photographs truly and accurately depict the vehicle, these areas of the vehicle, sir?
Yes,
Move to admit 113, 114, and 115, permission to publish.
Exhibits 113, 114, and 115 are all received. Permission to publish granted.
Reaper, I'm live.
Please. Oh.
Jury would let me know when the jury box monitors are on. All right, thank you very much.
All right. Please describe 113, sir.
that is an apparent fired bullet defect that's in the windshield of the Ford Escape.
Is that the rear view mirror on the left side of the picture?
Yes, this photograph would be from the inside, looking
I see what you're
through
saying.
the windshield.
Were you able to tell the path of travel? For
No,
the
I have
bullet?
not.
Objection.
Yes,
Speculative.
Please describe.
Overruled. You may answer.
yes. The fired bullet that caused this defect most likely came through that rear passenger window that was shattered and entered the vehicle and then exited the vehicle through the windshield.
Ah, I see.
So that's a exit damage that we're seeing there.
Yes.
How can you be sure?
Windshields have laminated glass, and so the directionality of a fired bullet going through laminate glass.
Shannon, thank you for the $5. No, they cannot.
Laminate tape.
Absolutely not. They cannot do that.
Shows the direction of the fired bullet.
Okay. Number 114, please. Please describe.
That's an apparent fired bullet defect. I call this a striking defect. That's on the roof rail of the passenger side of the vehicle.
Okay. Why do you call it a striking defect?
It didn't penetrate any part of the vehicle. It was more of a glancing kind of ricochet.
Okay. And then number 115.
So those were all the
Zoom in
bullets
on
are
that,
at.
back left.
Right there. Windshield on the other side.
Please describe.
This is an apparent fired bullet defect. I call this a perforating defect because it actually went through the exterior door skin and went all the way through into the inside of the vehicle.
Did you ever find the fired round in the vehicle?
Yes, I did recover a fired bullet and fired bullet fragment from the rear cargo area of the vehicle.
Okay. Was there any evidence that that bullet traveled any further than the cargo area of the SUV?
Objection. Speculative.
Overruled. Based upon the witness's training
He
and
can't-
experience and examination of the vehicle, he may.
Okay, he does. I think he did this before with another expert witness. He doesn't fucking understand. Expert witnesses, once they've laid the foundation as to their expertise and training and experience, they can be classified as an expert witness, which means that they are permitted to speculate within the confines of their expertise. He does not understand that because, again, he's an idiot.
Answer.
No, the bullet stayed in that rear cargo area.
Okay. Now, aside from examining the interior and the exterior of the vehicle at ground level, did you attempt to look underneath the vehicle?
Yes, the first processing strategy, if we go back to that, I wanted to get everything collected from all sides of the vehicle and inside of the vehicle before putting it on a vehicle lift to examine the undercarriage of the vehicle.
So you did do that.
Yes.
What kinds of things are you looking for on the undercarriage?
Looking for anything that shouldn't be normally present on the undercarriage of the vehicle. So I was looking for any hairs, fibers, any potential biological fluids such as blood.
Did you find any such objects?
Objection leading.
Overruled. He may answer.
Yes, I did.
Did you collect those items?
Yes, I did.
You had described for us earlier swabbing of the steering wheel on the interior of the vehicle. Do you recall that?
Objection leading.
Overruled. The witness may answer.
How do you go about swabbing a steering wheel, sir?
Objection. What's the relevancy?
Overruled. The witness may answer.
The best
I
way
don't
to
know.
collect
Maybe to
DNA
get an idea, maybe to possibly get fingerprints to get an idea of the driver of the vehicle. You fucking idiot. I should stop.
from a surface is to use a two swab technique. The first swab is a swab that's slightly moistened with deionized water, and basically swabbing the surface and then following up that swab with a dry swab. So it's a two swab process, a wet swab followed by a dry swab, and that becomes one item of evidence.
Same thing for the gear shift?
Yes.
What do you do with these swabs after you collect them?
I put them into the appropriate container and then seal that container, write my description of that particular item of evidence.
By the way, people, this is actual CSI. This is actual evidence collection, chain of custody, all that jazz.
Case, those items, anything for DNA.
Thank you, Kit 190 for the $2.
Analysis unit.
Did that happen?
Yes, that did.
And how about the hat, States Exhibit 87? Did that get transferred to another unit for further analysis, to your knowledge?
Yes. So any clothing item that's
Hold on. There was an objection. Grounds?
Relevancy.
Overruled. The witness may continue answering.
He's
clothing
so,
items that are
he's
worn
so
by
salty.
individuals are a really good source.
He's so fucking mad.
So, yes, I collected that hat and it was transferred
Man,
to the
stay mad.
analysis unit.
Your report, Exhibit 90, did you believe that to be a true and accurate narration or summary, I should say, of your work in this case, sir?
Yes, I do.
Mr. Shuckler, thank you for the $2.
Number 90, Your Honor.
Objection. Relevancy.
Overruled. Exhibit 90 is received.
I don't have any other questions then, Your Honor.
Oh boy, here we go. This will be fun.
Thank you. Cross-exam, please.
You said you do DNA analysis, correct?
No, I did DNA analysis for nearly 10 years. I don't actually do DNA analysis anymore.
So at the time of the incident, were you doing DNA analysis?
No.
So who did the DNA analysis on all the items that were found during your investigation?
DNA analyst Trevor Naylet.
Did you see the results of those DNA
Analyses?
Did you see the results of those DNA tests?
We did have conversations.
Did you see them?
No.
The reports?
So it'd be fair to say you don't know what those results were.
I didn't verify it. Like I said, we just had conversations.
So do you know the results of the DNA analysis?
In particular, is there a particular item?
For any of the items?
I don't recall the exact results, no.
His job is evidence collection, I believe. So it may be that he may not know or recall what the results were. I believe he's testifying to the evidence collection.
The gunshot that you stated stayed in the rear cargo. Where in the rear cargo did you find that shell casing?
Objection, that's a misstatement. It
That's a
wasn't shell
misstatement.
casing, Your Honor.
He didn't say shell casing.
Fragment, same thing.
No, it's not.
I'll sustain the objection. It mischaracterizes the testimony and ask that you rephrase it.
Did you find a shell casing? A bullet fragment?
I found a fired bullet fragment.
Where did you find the fired bullet fragment?
It was really close proximity to where the rear latch comes down and hooks in to stay closed. So on the floor of the rear cargo by where the actual cargo door comes down.
And you said a latch that comes down?
Yeah,
my God.
so how doors latch,
Yes.
car doors latch, you know where the
Yes.
latch is?
To lock in.
Where the rear cargo door came down and latched, it was in really close proximity on the horizontal surface of that rear cargo area.
Did you observe if the bullet fragment had struck anything?
It struck some items in that rear cargo area.
Do you recall what it struck?
I don't.
You made reference to a headband being on the rear view driver's side mirror, correct?
Correct, it was on the driver's door mirror.
That's a good point, Juan Galt. I'll
And
probably
from your
reference that later.
expertise, how would you, in your opinion, guess that it got there?
By coming into contact with something or someone that was wearing it?
And do you know that for sure?
No, but based off of my experience of a lot of years of examination of physical items of evidence.
But it'd be fair to say that you don't know exactly.
No, I wasn't at the parade. No.
You're right. Yeah, he can only speculate that it was on
And
somebody's
stated that you
head
were present for
before
the towing
it was
of the vehicle,
fucking
correct?
hurt, before
Yes.
you ran into them.
Do you recall at any time anyone's attempting to start the vehicle?
No.
And you stated that the bumper was, I guess, moved at some point so it wouldn't drag under the vehicle. I'm guessing that's what you said. If I'm wrong, you can.
No, that's correct. Yeah, we used bungee cords to secure it off the ground so that when we're moving it or putting it on the flatbed to go to the actual enclosed trailer, that it wouldn't be constantly going underneath the vehicle.
When towing the vehicle, what was it placed on?
Because of the amount of traffic or cars that were parked on the road, the towing company couldn't get the enclosed trailer right to the end of the driveway. So the vehicle was put onto a flatbed truck and then driven a few houses down, where then it was transferred to an enclosed trailer and then removed from the scene.
So with the bumper, being that it was first placed on a flatbed truck, as you say,
So-called flatbed truck.
at that time, what the bumper had, what problem would the bumper had caused if it wasn't going to be physically dragged or anything at that point?
I'm not sure I understand your question.
What kind of problem would the bumper pose if the vehicle was on on a flatbed truck.
The whole point is
Essentially what I'm saying is, to give you more clarity, how could the bumper be dragged at that point?
it was being removed from the surface of the driveway onto the flatbed. So if the bumper weren't secured in an upright position, it would be pulled, and the bumper, as the vehicle is going this way, the bumper would be pulled underneath the vehicle.
So once it was secured on the flatbed truck, would the bumper still pose any problem?
The vehicle on the flatbed, the bumper was in a secured position.
If it wasn't bungee corded, would it have posed a problem?
Yes.
It probably would have
Also,
fallen
if it
off.
wasn't moving.
The whole purpose was to secure the bumper in place to preserve any physical evidence that might have been on the bumper.
Yes!
And do you recall who did the actual towing?
Oh my god.
The
company?
Is Complete Towing and Recovery.
And you stated to one to get the vehicle
He's
to
going to subpoena the towing company?
environmentally friendly, secure location.
Environmentally
A better
friendly.
term would be environmentally controlled.
What do you mean by...
This fucking idiot.
environmentally controlled?
What a goddamn idiot.
Proper lighting outside of the limits. Outside of view of the public. So an enclosed building.
Why the reference to outside of the public?
It's easier to do examinations in a controlled environment.
Would it be fair to say at that time, before it was towed, the vehicle had been secured, checked? That was done out in public. So what would be the difference at that point?
I'm going to go back to my original statement of what my primary duty is. My primary duty is to preserve the integrity of the evidence. So that night, I was concerned with doing the necessary steps that I deemed relevant to collect, and then get that vehicle to a more suitable environment, just based off of how much more work and analysis and processing that vehicle would entail.
Fundamentally, I follow what you're saying fundamentally. The question, though, is, by the time you arrived to the scene where the vehicle was located, were you aware that the vehicle had essentially been already investigated?
No.
So you had no knowledge that the vehicle had been secured, had been pretty much investigated by that point?
Well, I was aware that the vehicle was in a secured state. I don't know what happened prior to that. There was very little information that I received on the initial phone call because of the hectic nature of everything. So I had an address, and I knew that the vehicle was being secured by law enforcement.
So law enforcement were present when you arrived to the scene?
Yes.
And at that time you had learned, did you learn any knowledge from the law enforcement other than what you were told during the phone call?
No.
Do you recall who you were called by?
I was called by Special Agent in Charge Dave Klabundy of the Division of Criminal Investigations.
Do you recall what time you arrived at the scene?
I arrived at approximately 8:15 p.m.
Thank you, commentator, for the $20. Beers on me. Trust me, we all need one listening to Brooks BS. Thank you very much, man.
Do you recall anyone telling you or mentioning what time the vehicle had been found?
I don't recall.
So it'd be fair to say before you
Hey, Jeremy.
arrived on the scene,
He
have
had
no knowledge
photos presented to him at the very beginning
been
to
happening
refresh his
around the
recollection.
vehicle.
That's correct.
But he can't have them on hand while he's on the stand. No.
You say you made reference to a hat being found in the background. Do you remember saying that? Or in the backyard, rather. I'm sorry, not the background. The backyard, I meant to say.
Yes.
And at the time that you observed this hat in the backyard, do you, from your expert opinion, do you recall that having any relevance to the vehicle?
No, it was an item of evidence or a potential item of evidence that just seemed out of place. So in those types of situations, I always collect those types of items.
But you weren't sure at the time if it had any involvement with the actual vehicle?
No.
Was there anything significant that stood out about the hat?
Just the
No.
location.
Did you find any blood on the hat? Did you find, or is it just pretty much just a hat in the backyard?
I didn't do a thorough examination of the hat.
So as far as you were concerned, it was basically just taking in the evidence as a precautionary thing, or?
Yeah, it was an item that just seemed out of place, so I collected that hat.
Did you at any time obtain knowledge about the relevancy of that?
No.
No. His job was evidence collection. It was probably somebody else who was going to determine whether or not it was relevant to the case, relevant to the investigation.
All the photographs that you were shown, had you seen those photographs before today?
Yes.
Do you recall if they were taken the same night of your investigation or multiple nights or days, rather?
There were multiple days.
And do you recall why you had to, or do you recall why those photos had to be taken over a multiple day span?
Yes, the vehicle needed a comprehensive evaluation or processing examination of pretty much every single side and surface of that vehicle.
And to do that, photograph wise, would have took days?
Yes.
So when did you start actually doing an investigation of the items inside of the vehicle?
That would have been the 22nd, November 22nd.
So the next day.
Correct.
And so did you yourself do analysis of the outside of the vehicle?
Yes.
Same day, 22nd of November?
Yes.
So you kind of started the outside and the inside pretty much roughly at the same time?
Yes.
Do you recall how long your complete investigation took?
Mine along with my colleagues?
Yours.
Mine. The examination itself of just me examining the vehicle?
Just you.
Probably over 40 hours. And that does not include the report that I'm writing. It doesn't include the process of going through the report, everything. But my examination, at least 40.
And so I'm assuming you did the report after you completed the initial investigation part.
Yes, the report's a summary of my processing.
And define summary. What do you mean by summary?
Oh my God.
It pulls everything together. It details my examinations and any findings I have from those examinations.
I always view summary as not every detail, but pretty much like it's much as would be relevant, but not.
Oh my
every
God,
single
that's
detail.
because
Is that fair
you're
to say?
fucking.
This report is comprehensive in the terms of
That's
it lists every single item that was collected.
It's because you're a god. You only
So
have
why
a
would you refer to
GED, if
it
that,
as
you
summary?
dumbass.
It's a summary of the examination and processing. That's the best way to describe it. It's not a dictation. In other words,
What do you mean by
There-
dictation?
There are
Oh
other
my
reports
fucking. Oh
that
Jesus.
other agencies may do that are dictated, right? They're this. I did this, then I did this, then I did this. This is a summary. This isn't a dictated report.
So what exactly did you summarize in your report?
My examination and processing strategies that I used, and the items of evidence collected, and any relevant findings associated with those examinations.
Did you do any examination of the cell phones?
No, I collected those and transferred those to a detective with the Waukesha Police Department.
Do you recall who that detective was?
David, his last name is spelt, I believe, Foyen, Foyen.
So at the time that you turned the phones over, did you do any more work in regards to the phones?
No.
No.
He just said all he did was collect them and transport them to the guy at Waukesha.
Do you recall doing any investigation on the airbag control module?
No, I don't do that.
Do you recall obtaining a search warrant to conduct an inspection on the ACM?
I'm
No.
sorry, I didn't understand you.
An inspection of what?
The ACM, I guess that would be the air control module. I'm guessing that's what that's
Thank you.
referencing.
No, since I don't do that type of analysis or examination, I didn't obtain any search warrant with that.
Any reason why I would say that in the paperwork?
Objection vague.
Grounds.
Sustained as to the form of the question. As to what paperwork you're referring to.
You didn't even say. I
Guessing.
Oh my. He's just fucking guessing
I don't know
what report he's referring
what
to.
it will be called, but it says conclusion inspection summary.
Do you even know if it's written by him?
And the conclusion inspection or conclusion/inspection summary.
Okay.
Do you
Is
recall?
it from this witness?
Huh?
Is it from this witness?
Yeah.
Okay.
Go ahead. Go ahead.
You.
I don't
You.
think that is from this witness, John. I don't see anything like that in this Exhibit 90.
Oh my.
Perhaps still looking at Inspector Schultz's report from the State Patrol, the last witness.
What page number do you
Oh,
have?
you goddamn moron.
Compare it.
This says page 5.
Yeah, he's looking at the last exhibit from Inspector Schultz, 83.
It says Chief Christopher Johnson.
Oh, it does say that in 83. It says, if I can read for completeness, or you can, it says...
Thank you, Sothel, for the $2 for that engine control module. Thank you.
No, that's not what I'm reading from.
Okay. Chief Johnson had obtained a search warrant to conduct the mechanical inspection and to image the data retained within the escape's airbag control module ACM.
Yes.
Correct?
Yes.
Okay.
Airbag
So
control
that was written by
module.
Inspector Schultz, who just testified, not this witness. To clarify the record here.
Thank you.
Chief Johnson, so maybe that's where the confusion comes in.
The record would reflect this witness. His last name is Johnson, so I think that's
Yeah,
understandable.
I didn't know.
Skipping forward a little bit.
Do you recall at any time obtaining any type of search warrants pertaining to the vehicle in this incident?
Yes, I have obtained a copy of the search warrant.
And do you remember what that search warrant was for? What was the intended search?
To search the vehicle and process it for any biological fluids, hairs, fibers, any electronic equipment, any personally identifying information.
And the
Thank you, Mel, for the
ACM
$4.99 super chat.
would fall under the lines of the mechanical side of.
Yes.
Okay.
Mm-hmm. Still reading. Still reading.
During your inspection, did you observe anyone try to start the vehicle?
When I was with Investigator Schultz, when he came to my laboratory, he attempted to start it.
Now we're back live. Thank you all for being here. Please hit that like button. Let's get over 100 likes this evening. I appreciate it, guys. Thank you. While this guy is continuing to, read his notes in the middle of a test,
And after you already stated that your initial part of your investigation before the report totaled 40 hours. And at that time, after you had completed your report, did you do any more investigating in regards to the vehicle?
After my report was complete?
Yeah, after you had done the 40 hours that you stated with, and then the actual report.
No.
Correction, reading
Once
somebody
my
else's
report's
notes.
done, I didn't do any further examination of the vehicle.
And after
Thanks, Woodwork.
that was completed, had you received any follow-up from law enforcement after you had completed everything?
No.
Had you yourself followed up with law enforcement?
I mean, Mike
about
deserves
the
it,
investigation after you completed your initial part?
No.
You yourself didn't file any claims in this matter, did you?
No,
Oh, here we go.
You know of anyone who filed any claims?
Wrapping
in this
up.
matter?
I don't.
And do you recall who you were subpoenaed by to testify?
I was subpoenaed by District Attorney Sue Opper.
Do you recall when that was?
I believe it was sometime, I don't exactly recall when.
And did you follow up on that subpoena
No,
after you had received it?
no.
Gabriel, not
Have you
really.
any time seen or read any complaints?
The
in
AG
regards to
is
this
an
incident?
agent of the state, not the state.
Do you know who the plaintiff is in this matter?
Huh.
The state of Wisconsin?
Your mom.
Would you label that as a person, an actual human? Grounds.
There it is.
Sustained. Not relevant.
You ever actually seen the plaintiff in this matter? Grounds.
Sustained.
If you saw the plaintiff, would you be able to identify the plaintiff?
Objection,
Grounds.
irrelevant.
Sustained pursuant to 9611. Sir, please move on to a different line of questioning.
Just trying to establish who the plaintiff is, Your Honor.
Jury will disregard the added commentary.
Do you see the plaintiff present in court today?
Objection,
Grounds.
irrelevant.
Sustained.
The plaintiff is like the force. Surrounds
Would you
us,
consider
it
yourself to
penetrates
be an
us,
injured party in
it
this
binds the
matter?
universe together.
No.
No further questions.
Thank you. Any redirect?
Finally.
Just very briefly. Mr. Johnson, you said when you arrived on Maple Street there were police officers present,
That's correct?
and you said the vehicle was secure at that point.
Correct.
Objection.
What do you mean?
Leading.
The answer may stand. Next question. Overruled.
What do you mean by that, sir?
The perimeter was secured with crime scene tape, and there were officers that were standing at the location where the vehicle was.
Would it have been possible for a member of the public or any curious person to just walk up and touch the vehicle or do anything to the vehicle?
Objection. Speculative.
Based upon his training and experience, he may answer. Overruled.
They would have been stopped by law enforcement.
Thank you, that's all I have.
All right, thank you, sir. You may step down. While he's stepping down, if my jurors and anyone else in the courtroom want to stand, I do want to get through one more witness tonight.
And then the exhibits that Mr. Johnson has, Your Honor, what would you like done with those?
I'll take them.
All right.
I have 90 and 87.
Yes.
What was 87?
87 is a hat.
I'm not sure if I did move that, but I would move that into evidence, so we will need that item for the next witness, please.
Okay, I'll put that back.
Thank you.
Objection to that. That
Noted.
before you showed me that, I didn't even see what that was. If you would have
I'll
never
show it to
told,
you again.
I know, but if you never would have told me, I never would have even know what that was, because I didn't see it until you just moved it.
The witness had it up on the stand, but here it is. This exhibit marked as Exhibit 87. Go ahead and sit.
Thomas, thank you for the gifted membership.
Evidence. I believe there's an objection. It's
Yes,
noted,
there is an objection.
overruled based upon the testimony of the prior witness. It is received. And who do we have coming up to the stand?
Your Honor, the state next calls Trevor Naylet, and for the record, he was handed a copy of Exhibit 91 on his way to the witness stand.
All right. Thank you. Sir, could you please stand and raise your right hand? My clerk, Teresa, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
It's a DNA expert? Is that what people are saying?
For the record, what is 91? I know you're going to get to it, but
91 is Mr. Naylet's report, Your Honor.
all right. Thank you. Then, all right. Good. I guess evening, sir. The first thing I will have you do is to state your first and last names for the record, and then spell each, please.
Sure. My name is Trevor Naylet, TREVORNALEID.
Thank you. Go ahead.
Thank you, and I'm sorry for mispronouncing your name. Sir, where do you work?
I am employed by the Wisconsin Department of Justice at the State Crime Laboratory in Madison.
And what is your position there?
I'm a senior forensic scientist in the DNA analysis unit.
How long have you worked there?
11 and a half years.
Could you please describe the work you do there?
Sure. I examine evidence for the presence of biological fluids such as blood, semen, and saliva, and then attempt to extract the DNA from those items. From there, I will make comparisons to standards from known individuals in the case.
And what's your educational background, please?
I have a bachelor's degree from the University of Wisconsin-La Crosse in biochemistry and a master's degree from the University of Florida in forensic DNA and serology.
Do you have any training specific for your position at the Wisconsin State Crime Lab?
I do, yes.
Please describe that.
Laying the foundation.
I underwent approximately a one-year-long internal training program that included the screening techniques we use, presumptive and confirmatory tests for blood, semen, and saliva. Excuse me. From there, I learned the extraction techniques, quantitation, amplification, and typing methods that our lab uses. From there, I learned data interpretation as well as statistical analysis.
Oh shit, he said he went to college in La Crosse? Oh no.
Did you do
Uh-oh.
any casework while you were in training?
The La Crosse
completed two
lore expands.
competency tests, 2 mock cases, a mock court, and then after completing those, I completed an extensive written exam as well as statistical tests.
Did you actually work with DNA samples, processing and analyze DNA samples during your training?
I did, yes.
About how many times?
About 175 samples.
Is the Wisconsin State Crime Lab accredited?
Yes, it is.
What does that mean?
Our lab's accredited under the ISO.
Thank you, Dory, for the membership.
2017. Essentially, it's just a voluntary program that any lab can enter to show that it meets established standards. They control our proficiency testing that's done twice a year.
Do you personally have any certification or accreditation personally?
No, just the lab accreditation.
Just the lab, okay. How many forensic DNA cases have you worked?
Just
Experience.
over 500.
Damn.
And about how many DNA samples have you processed?
Over
Objection.
2,000.
Damn.
Well, the witness may answer. I'm sorry. Will you repeat your answer?
Over 2,000.
Have you previously testified in court before?
Objection, relevancy.
Overruled. The witness may answer. As a reminder, there may be objections. Please wait until I rule on those objections until you answer. Go ahead. You may answer.
Thank you. I'd like to ask you a little bit further about DNA analysis and how that works, okay?
Sure.
What is DNA? We hear a lot about it. What is it?
DNA stands for deoxyribonucleic acid. It's essentially the genetic blueprint that makes us what we are. It codes
Thanks, Taco, for the $2.
2 legs, 2 arms,
Lacrosse bingo. True.
etc.
And where's DNA found in the human body?
Objection, eating.
Overruled, foundational, the witness may answer.
DNA is found in the nucleus of a cell.
Is
And
it the same?
mitochondria is the
cell in our
powerhouse.
body?
In every cell that has a nucleus, yes, such as white blood cells and skin cells.
And is that important in your analysis?
Objection leading.
Overruled, foundational, you may answer.
Anonymous, thank you for the 1337
Objection leading.
the lead super chat
Go ahead.
or tip.
It's important because we can take samples, evidentiary samples that may be from blood or saliva, and compare them with known standards, which are typically buccal swabs, which are swabs from the inside of the cheek, or dried blood standards in the case.
Does each individual have unique DNA?
Everybody except identical twins is unique.
Okay. Are you familiar with something known as STR analysis?
Objection leading.
Overruled, foundational, the witness
Well-
may answer.
Yes, I am.
What is STR analysis, please?
STR stands for short tandem repeat analysis. Over 99% of DNA is the same from person to person. So we're looking at that 1% that varies from individual to individual. Short tandem repeats are very small sequences of DNA that repeat over and over. So at one location, I may have 12 of these repeats, where another individual may have 14.
Is that distinction important?
Yes.
Why?
We can type standards from anybody associated with the case and make comparisons from the evidentiary profile to the standards to either include or exclude individuals.
All right. I'd like to direct your attention to Exhibit 91. Do you have that item in front of you, sir?
Yes, I do.
What is 91, please?
91 is my confidential report of laboratory findings dated April 29th, 2022.
And do you know if it relates to events occurring in the city of Waukesha on November 21 of 21?
Objection leading.
Overruled, foundational, the witness may answer.
Thank you,
Yes.
Kelly.
Okay.
For the membership.
Were you given some items to process for DNA analysis?
I was, yes.
Were you given DNA standards to compare any profiles that you may develop from the evidence to known individuals in the case?
Yes, I was.
Do you remember who you got standards from?
I do.
Are you able to name them? Or if you need to refer to your report, you may, but just let us know.
Okay. Can I read off the report?
You may read off your report. What page are you reading from, sir?
I will be reading page 2.
Okay, go ahead.
Objection.
Overruled, the witness may do so.
I received buccal swabs, so cheek swabs, from Erica Patterson as well as Darrell Brooks. I received dried blood standards from Wilhelm Hospital, Tamara Durand, Jane Kulik, Leanna Owen, Virginia Sorensen, and Jackson Sparks.
Is there a difference between those two, the method in which they were submitted, the buccal swab versus the dried blood standard?
Objection leading.
Overruled, foundational, the witness may answer.
Yes,
Are you able to do the same thing with them?
I am, yes.
And what is that?
Just extracting the DNA off them to essentially put a profile to the individual.
Okay. And how do you use those profiles that you develop from the known standards?
We compare them to the evidentiary profiles that we develop.
All right. Now, you processed many items related to this case. Is that correct, sir?
Objection leading.
Overruled, foundational, the witness may answer.
Yes, I did.
I'm going to direct your attention to just a few select items for my purposes, okay? On page 7 of your report, Exhibit 91, you have reported on analysis you were able to perform on some swabs from the steering wheel of the vehicle in question. Is that correct, sir?
That's correct.
And the swabs were obtained by another member of the crime lab, is that right?
Objection speculative.
Overruled, the witness may answer.
That's correct.
How do they get
True, Gary.
They were collected by analyst Chris, our chief now, Chris Johnson in Milwaukee, and they were mailed over to.
Yeah, Gary, real brief. Gary makes the good point. Imagine if he had to read off all 60+ names of everyone he hit that night. He didn't. He listed off the 6 deceased victims and his ex-girlfriend, because that's how the because for the charges that he got for the people who were hit, they don't necessarily need to show that there's DNA or on all the victims. They only need specifically the DNA of the people that they're charging. He's charging with homicide and I think domestic. I think this is what he's also being charged with.
The Madison lab.
Okay. Were you able to develop any DNA profiles from the swabs of the steering wheel in this case?
Yes, I was.
What were your findings?
It was a 2-person mixture with at least 1 male.
Can you explain for the jury what that means, please?
We can look at a profile, and based on how many peaks there are at different locations, each person will have a maximum of 2. So if you have 3 peaks at a location, you know that you have more than 1 person there. And so in this case, we were able to say that it was a 2-person mixture.
Were you able to identify who those 2 people would be?
Objection, speculative.
Overruled. The witness may answer based upon training, experience, and investigation and analysis in this case.
Yes.
How did you do that, sir?
I ran it through this program called StarMix.
Is that a computer program?
Yes, it is.
What is that, please?
Objection, leading.
Overruled. The witness may answer.
StarMix
Thank you,
is a
Shannon,
mixture
for
deconvolution software that we use. Previously,
the membership.
it was pretty difficult to distinguish different contributors in mixtures, and now we have this software that's actually a 2-part program to do that.
How does it work?
Objection, leading.
Overruled. You may answer, sir.
The first part takes inputs by the analyst, such as number of contributors, so we'll look at the profile and determine that, but it also looks at the total amount of DNA amplified and essentially makes its own profile for comparison purposes. It will then compare it to the actual profile and determine if it's a good enough match. It will then generate another completely random profile, and if it's better and a better match, it will accept it. If it's not, it will deny it, and it will keep doing the accept over and over hundreds of thousands of times until it has a profile that is a very, very good match to the theoretical profile.
Safe to say a human being will be very challenged to do the same analysis.
It would take a very long time, yes.
Okay. And the software that you use, the StarMix or STRMix, is that used in other labs around the country, sir?
Objection, speculative. I don't know it's used around the country.
Overruled. The witness may answer.
Yes, it is.
Is it a reliable method of performing DNA analysis, in your opinion, sir?
Yes, it is.
Has it been accepted in courts and other cases?
Objection, speculative.
Overruled. The witness may answer.
Yes, it has.
More than once?
Objection, leading.
Overruled. You may answer.
Oh, it's not.
Yes.
Oh my God.
Do you know about how many times StarMix has been used in Wisconsin courts?
Objection, speculative.
Overruled. The witness may answer.
Since we brought it online in January of 2020, it's been accepted over 100 times in the state of Wisconsin.
Did you have to receive some specific training in how to utilize this software?
Yes, I did.
And did you complete the courses?
Yes, I did.
Okay. Did you use StarMix to analyze the DNA profile, this 2-person mixture from the steering wheel?
Thank you, Nessa Allen.
Objection, leading.
Overruled.
For the membership.
Foundational. The witness may answer.
Yes, I did.
What conclusion did you draw?
Based on it being a 2-person mixture, Erica Patterson and Darrell Brooks are both very strong support for inclusion. They're both it's at least 1 quadrillion times more likely to observe the DNA profile if it's a mixture resulting from them plus an unknown over 2 unknowns.
So the odds of it being Mr. Brooks' DNA versus some other random person in the world are very, very rare, correct?
Objection leading, and I don't consent to being called that name.
The objection is noted. I'll sustain the objection as to the form of the question. Just ask that you rephrase.
Can you explain?
I like how when he keeps on saying that, he's inadvertently confirming that he is that name, that he is the identified individual. He's done this so many times before, and I don't think he realizes it.
For us, what you mean by very strong support for inclusion?
Yeah, we have a verbal qualifier based off of the validation that the company, the StarMix creators, as well as an internal validation have come up with. And the highest number we'll report is greater than 1 quadrillion. So this is higher than the number we're reporting greater than 1 quadrillion, but the number is actually higher than that.
Okay. I'd like to move on then to the gear shift. Did you receive swabs from the gear shift of the red SUV?
Yes, I did.
Were you able to develop a DNA profile from the swab from the gear shift?
Yes, I was.
What did you find?
That was a 3-person mixture, also with at least 1 male.
I'm sorry, you trailed off at the end. A 3-person mixture, what?
With at least 1 male contributor.
Okay. Were you able to do any further analysis on that DNA profile?
I ran that through StarMix as well.
And what conclusion did you reach?
Objection leading.
Overrule. The witness may answer.
The same as the steering wheel. So Erica Patterson and Darrell Brooks are both very strong support for inclusion.
Meaning that their DNA is on that gear shift.
Objection leading.
Sustained as to the form of the question. Please rephrase.
Please, again, state in layman's terms for the jury what that means, sir.
Both Erica Patterson and Darrell Brooks, there's at least 1 quadrillion times more likely that it's the mixture of, it's at least 1 quadrillion times more likely to observe the DNA profile if it's a mixture from H1, meaning the person of interest, and 2 unknowns versus
Person of interest. You changed his language.
Person of interest being Darrell Brooks.
Objection. I don't consent to being called that name.
Overruled. Noted, but overruled. You may answer.
We run StarMix for the profile itself, and then each individual standard is run. So each person will have its own individual stat. So in this case, both Erica and Darrell are greater than 1 times 10 to the 15th, which is our 1 quadrillion.
All right, thank you. Sir, up on the table to your left, there's an item in a bag that's been marked as exhibit number 87. You see that? Yes, could you pull that down and take a look at that for me, please? Do you recognize exhibit number 87?
I do, yes.
And is that an item that you worked on?
Yes, it is.
Were you able to develop a DNA profile from exhibit 87?
Yes, I was.
What did you find?
That was a 2-person mixture with at least 1 male contributor.
And were you able to analyze that further using StarMix?
I was.
What conclusions did you reach?
Erica Patterson has very strong support for exclusion. Darrell Brooks has strong support for exclusion. Wilhelm Hospital has very strong support for inclusion. He is above that 1 quadrillion threshold that we have.
Okay. And last, I'm not sure, Madam Clerk, if you still have the exhibit handy. If not, we can just talk about it. I'm looking for the sweatshirt that was item number 84. Exhibit 84? It is? Okay. Judge, would you please hand that to the witness?
Yes, the record reflects I'm handing exhibit number 84 to the witness. Go ahead.
Thank you.
What was the other exhibit number? That?
The hat is 87 and the sweatshirt is 84.
Sir, do you recognize item number 84, or exhibit number 84, I should say?
I do.
Is that an item that you processed?
Yes, it is.
Were you able to develop a DNA profile from exhibit 84?
Yes, I was.
What did you find?
I first looked at this. Typically, we'll swab, if we're trying to find the wear of an item, areas that skin contacts. So on shirts, a lot of times we'll swab the back of the neck area or the cufflinks. So I swabbed both of those. There was a reddish brown stain on the right sleeve that tested presumptive positive for blood. So I took that, a cutting of that. And then there were 5 hairs. There were more than 5 hairs, but I took 5 hairs that looked like they had roots on them for extraction.
Okay. And were you able to develop any DNA profiles from any of those swabbings or hairs?
Yes, I was.
Which? Let's start with swabs.
Okay. The swabbing of the collar of the sweatshirt was a 3-person mixture with at least 1 male.
How about the cuffs of the sweatshirt?
The cuffs were also a 3-person mixture with 1 male.
And how about the stain on the right cuff?
That was a 2-person mixture with at least 1 male.
Okay. Going back to the collar, the swab of the collar, did you use StarMix software to rule in or out the possibility of Mr. Brooks being included in that profile?
Objection. I don't consent to being called that name. Is leading the witness.
Noted, overruled, the witness may answer.
Yes, I did.
What was your finding?
Mr. Brooks has very strong support for inclusion. He's above that 1 quadrillion threshold.
Okay. How about the cuffs on the sweatshirt? What was your finding and ultimate conclusion as to Mr. Brooks' likelihood of DNA in that mix?
Objection. I don't consent to being called that name. Leading the witness.
Noted, overruled, the witness may answer.
That 3-person mixture with at least 1 male, the same thing. Darrell Brooks was very strong support for inclusion, greater than 1 quadrillion times.
And the last item you said was a stain on the right cuff of the sweatshirt?
Correct.
Possibly
Any,
fizzy.
ultimate conclusion as it relates to that item?
That was a 2-person mixture with at least 1 male contributor.
And what was your conclusion?
Both Erica Patterson and Darrell Brooks are very strong support for inclusion.
You said that substance was a presumptive positive for blood?
Correct.
Objection. Leading.
Overruled, the witness may answer.
That's correct.
All right, thank you, sir. I don't have any other questions at this time, but I would move Exhibit 91 into evidence, his report, Your Honor.
Thank you. I'll take Exhibit 91 is received. Any reason to keep the exhibits the witness?
Can I see that last exhibit? I'm thinking
91?
of the 87 with the sweatshirt.
You want me to hold it up? Or
Yeah. Is that 87?
No,
84.
84?
84.
This hat that I'm holding up is 87. And then he has 91, which is his report. I'll keep that in front of him for now, or he can keep that in front of him for now. Go ahead when you're ready.
These DNA analysis with StarMix, I'm a little curious
Oh
to
God,
get clarification on
this is gonna be painful. Strap in, people.
what does it mean when you say mixture. What exactly does that mean?
A mixture just means that it is more than 1 person present in the profile.
So by it being more than 1 person present in the profile, would it be fair to say that that would constitute it being more than one person?
Yes.
Yes! God damn it! Fucking idiot.
The gear shift had a 3-person mixture, so would that apply to the gear shift the same, that it would likelihood there's 3 different people's DNA on the gear
Oh my god. Alright. I'll be right back. I'm sorry, I'll be right back. Jesus Christ.
and for the steering wheel,
Oh
a
no.
2-person mixture, so that would be 2 people for DNA for the steering wheel.
Correct.
Do you recall when you did this DNA analyzation? I'm sorry.
On any specific item, or all of them?
Do you recall when you did all the items, I guess?
So most of the items were collected in November. They were not transferred to the Madison lab until the end of January. So I started, I believe January 31st was the first day that I started analysis. And then my report was written April 29th.
So you started the analysis at the end of January,
Correct.
and you did your report in April. Why so long?
I generated 583 pages and my report's 15 pages long, so that takes a little bit of time.
Yeah, a little bit.
So you broke down the 583 pages into 15.
Correct.
To the best of your knowledge, do you know why it took from November to January for you to actually get the items that you were going to analyze for DNA?
Other than me picking up the case then, not really, no, I don't know.
Do you know where the items were kept prior to you receiving them?
Yes.
Can you state for the jury and for the record?
Our evidence technicians, when they came to the Madison lab, put them into storage where all evidence is stored.
Were the items sealed like they are now?
Yes.
And so I'm assuming you had to unseal them, get them out of the sealing packages to do the analysis.
Oh, he's gonna try and see if he can say that they were contaminated or something.
And did you yourself alone do the analyzation, or did you have other people that you worked with?
I did all of the DNA myself.
Did you repackage the items after you were done yourself?
Yes, I did.
And did you return them back to where you had received them from, or did you keep them at your, I think you said the Madison lab?
I'm based out of the Madison lab, yes. Typically, when we're done with evidence, we will return them to our evidence technicians, who will then put them back into storage. When the case is done, the evidence is then returned to the submitting agency.
So the items are still at your lab, is from your knowledge?
Now?
Yeah.
No.
No, they're here.
Well, I asked that, let me give you some clarity. I asked that because you said at the completion of the case, they would be returned to the agency that you received them from. So I was kind of trying to get clarity on that.
Oh my God.
So do you know if they were returned to the agency you received them from already?
I believe they were.
So it'd be fair to say in this situation, the items weren't continued to be stored at the Madison lab.
That's correct.
I noticed that specifically the DNA was analyzed for 8 people. Would that be fair to say?
Sounds right, yes.
And specifically referring to the analysis that had 3-person mixtures and things of that nature, what happens to the 3rd-person mixture that is excluded? Is it any way?
The question.
Oh, I'm sorry.
I'm sorry, I don't understand the question.
Well, I guess I'm referring to when someone is excluded, which I interpret as ruled out, there's still that mystery 3rd mixture. Can that 3rd mixture be identified in some way, or how does that work?
Sorry. Yes, we would need a standard submitted from another person who they believe could possibly be the source of that DNA.
They only will match
So would it be fair to say for
the swabs that they already got?
analysis that you did that had 3-person mixtures, there's still a DNA that you found that's unknown?
That's correct.
But I think he said that it was excluded, right? I can't recall what he said specifically. I don't even know which piece of evidence that he's referring to.
And can you explain what is CODIS? Is that pronounced right? CODIS or Kodak?
Yes, it is.
Can you explain what CODIS
Sure.
is?
CODIS stands for the Combined DNA Index System, and it is a database of known individuals.
So if you have been arrested before, you probably have had yourself swabbed, and so you're put in the database.
And when you find that a DNA, I'm guessing, I don't know if the right word to use would be sample, or I don't know if that's correct. When you come to the conclusion that a DNA sample is not eligible for entry into CODIS, what exactly does that mean?
There are certain rules that we must abide by for putting profiles into CODIS, depending on where it's collected from. Pretty much determines the eligibility on whether or not we can put it in.
God. You skip ahead.
This had one of your analysis had a 4-person mixture. Were you able to determine out of the 8 DNAs that you ran if any of those DNAs were found on that specific item?
Your Honor, I object that it's vague. I'm not sure which item he's referring to.
I'm referring to, it says brim of maroon winter style hat.
What page are you on, please, sir?
6.
All right, so you want directing the witness to page 6?
Yes.
that particular
Yes,
item?
that's where I'm reading from. Yes.
Okay, thank you. Did you ask the question?
Yeah, I said this one in particular, the one I'm referring to, has a 4-person mixture. Did your analysis identify any one of those 4 people out of the 8 DNA samples that you were analyzing?
No, it did not.
Would it be fair to say for pretty much all the items that you did analysis on, there were at minimum 2 or 3 person mixtures?
No.
And why would you say that?
Typically in our reports, we lump the star mix samples together. If you look before that, it will have items that were single source profiles.
That's why I said the majority, or if not all. I didn't say every single one.
I wouldn't
Okay.
say the majority, no.
Okay. Randomly aggressive. I don't fucking idiot.
Certainly looks that way.
What is wrong? No, I know. We all know what's wrong with him. Fucking dipshit.
Is it autosomal? How do you say that word?
Oh my god.
Autosomal.
Autosomal. Autosomal. I don't even know what that is.
STRDNA results and conclusions. That starts on page 5. Would that be fair to say?
That's correct, yes.
Hold on.
And ends on page 13. Would that be fair to say?
That's correct, yes.
Would it be fair to say that page 13, 12, 11, 10, 9, 8, 7, and 6, out of all those pages, only 3 have single source, and all the rest of them have at least 2 or 3 mixtures. Would that be fair to say?
No.
And can you point out where the inaccuracy may be,
Sure.
in case I'm not being accurate?
Yeah, on page 6, the first profile that you're looking at, cuttings of the apparent hair from the gas tank strap. That's a single source profile.
That's one.
The next line, the cutting of the unlit end of the blunt is 1.
2.
Cuttings of the apparent roots from the hairs, which is CC4, CC5, and CC8. So that's 3 items right there.
So you're looking at the actual heading.
That's correct.
And is that it from
On that page, yes.
Any other pages?
I can't skip, sadly.
I don't consent to being called that name. We're going from page 6.
Are you asking single source profiles?
To page 7. From
Yes,
page
we're
7,
live right now.
Single source, or yes, I guess it would be called single source.
No. From page 6 to 13, as you previously stated, those are my star mix ones. So each one of those is going to be a mixture profile.
So the majority of them have mixture of persons.
From those pages, yes. But there are many single source profiles before the star mix conclusions.
Do you recall who you turned your report over to once you finished your report?
For technical review?
I'm sorry, can you repeat that?
For technical review?
I'm referring to once you had finished your written report. Do you recall who you turned that over to?
Yes.
Can you state it for the jury and for the record?
Kelly Gajewski was my tech reviewer.
Can you spell that last name for the record?
It's Gajewski, Gajewski.
Thank you.
And do you know what happened to the written report from that point?
After she reviews it, sent it back for edits, and then I fixed those. It was approved by her. Then it goes to a supervisor for an administrative review.
Fix the edits? What do you mean by fix the edits?
If there's any typos or anything like that, it'll come back. Or if I forgot to initial a page or something like that, I'll fix those and then send it back to her for approval.
Yeah, I was gonna say, Danny. Edits, manipulation.
Working with law enforcement, which you've stated you've done numerous times. And in regards to written reports, to your knowledge, are you aware of officers taking a creative writing course?
Objection.
Objection! Relevance!
Sustained. That's the fourth question.
Oh my god, he's really gonna try that. Creative writing course. This fucking guy. That's his play. That he somehow manipulated the report.
Ever took in a creative writing course?
Sustained.
Jesus
Not
Christ.
relevant. Next question.
Have
He
you
does
or
DNA
anyone you know
He does DNA analysis.
Complaint this matter?
Oh my fucking god. He does DNA analysis. He
Consider
doesn't
yourself an injured party
write
in this
police
matter?
reports or police narratives.
Ever directly talk to the plaintiff in this matter?
I don't know how I would talk to the state of Wisconsin.
Can you repeat that? I'm sorry.
I do not know how I would talk to the state of Wisconsin. It's an entity, not a person.
Not a person, right? No further questions?
Any redirect?
Yes. Sir, on page 6 of your report, you were identifying for the defendant the some of the single source profiles that you developed. Do you recall that?
Yes.
And one of the items you described as items CC4A, CC5A, and CC8A. Do you see that?
Objection leading.
Overruled, the witness may answer. Go ahead.
Yes, I do.
What do those items represent?
Objection leading.
Overruled, the witness may answer.
Those are cuttings of the apparent root ends of the hairs that I took off the sweatshirt.
Got to ask you about the hairs.
Objection leading.
Did you? I'm sorry, that was a statement. I'll move on, Your Honor.
Thank you.
You told Mr. Brooks on cross that you developed a single source profile for those hairs. Is that right?
Objection, I don't consent to being called their name, and it's leading the witness.
It's not.
The objections are noted. Overruled, the witness may answer.
Who was the source of those hairs on that sweatshirt, State's Exhibit number 84?
Objection speculative.
Overruled, go ahead and answer.
Darrell Brooks is the source.
Thank you. Nothing else.
Great, thank you, sir. You may step down. As much as I would love to have another witness, we're going to break for the night because it is 5:49. So, with that, I will give the instruction that I've been giving every night to the jurors.
Is he happy that he got a gotcha at the end of the cross
The
that
evidence is presented, and I have instructed you on the law.
the plaintiff isn't a person or something?
Or with anyone else until your final deliberation in the jury room. This order is not limited to face-to-face conversations. It also
All right, I don't know who the hell is manipulating
communications.
papers in the mic, so I'm going to turn it down here for y'all's sake.
Phone or computer, text or instant messaging, or social networking sites to send or receive any information about this case or your experience as a juror. If you come in contact with the parties, lawyers, interpreters, or witnesses, do not speak with them. For their part, the parties, lawyers, interpreters, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene, either in person or by any electronic means. Do not read any newspaper reports or listen to
Nobody's
any
ready,
news reports
philosopher.
on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics, applications, or tools with communication capabilities to share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so despite your telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening to discuss this case with another member
hell
of
is he
your
looking at?
household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After the trial is completed, you are free to discuss this case and communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. With that, you are excused for the evening. I'll briefly discuss scheduling with the parties and then let Michael and Jen know when to report tomorrow. Thank you. All rise for the jurors, please. We good? Oh, there's the door. Thank you. Be seated. Just briefly as to scheduling tomorrow, since we had a late evening, how about we start at 9 a.m. tomorrow? Any objection from the state?
No.
From Mr. Brooks? No. All right, 9 a.m. tomorrow. For scheduling purposes, I'll take up, obviously, tomorrow morning, whether the state can recall Detective Casey. That would be your last witness.
Yes.
All right, then, sir, you have the option, should you choose, of an opening statement. So you should be prepared for that. And then to call witnesses, I believe you've worked with Attorney Opper, or do you need a provider with anything regarding that tomorrow? All right, anything else from the state?
No.
Any-
I don't have anything at this time, Your Honor. If you excuse us, then I'll make sure I get that paperwork from Mr. Brooks or the defendant, and we'll be ready to go.
All right, anything else from you, sir?
Oh, yeah, we're starting at 8:30, right? Or are we starting at 9 as well?
We're starting at 9.
Okay, then Ms. Basie corrected me because we have to discuss Attorney Casey's testimony, but we also anticipate we'll have a motion in the morning, or I can tell you what it is right now, but I know the
Well, we
hours
can
getting
then,
late.
I mean, if you think it's gonna take some time, then I'll have the jurors come at 9, but I wanna be mindful. I know, Mr. Brooks, we all had a long day. I'll do 8:45, but I'm not gonna do any earlier than that.
I think
Did he agree to? Did he catch
It's
that?
a
I missed that.
motion to conform the information to fit the evidence.
Oh, all right, I'll take
What
that
is
up.
that?
We'll have it in writing for Mr. Brooks in the morning, Your Honor.
Okay, that'll be great. All right. Anything else from you, sir?
No,
You didn't object there.
Yeah. It's not the exact order that I'm gonna call the witnesses, but it's pretty much
Who you want, like each time block, morning or afternoon?
exactly.
You'll be ready to
It's
go
just
tomorrow?
not an exact order like I'm gonna call this person.
I'm
this
not gonna hold you to
person.
that, as long
Yeah.
as it's by time blocks, if you wanna call it that, but be ready to
Well,
call
I did
witnesses.
it just so I can state for the record, so it'll be easy to follow. I did the names by threes. I'm guessing the first 3 would be the morning, the next 3 would be the evening, and then Friday, 3 morning, and then 3 evening. Is that fair?
I think so.
Yes, we may be able to move faster, but we will attempt to stay in contact with the witnesses if we can, bring somebody here sooner. If the court's got time, we'll do that, but that's very reasonable.
And then do you have any idea how long you anticipate your opening will be?
Opening statement?
Yes.
I don't think it's any way to gauge how long it will be.
Just be mindful, sir, it's not the time to make argument, opening statements, as I like to call them, and what the jury instruction references, it's the roadmap. So I will expect to hear a lot of the evidence will show, the testimony, things of that nature. If it turns into argument, that's what happens at the close of the case.
What do you mean by argument?
If you're trying to argue the evidence and what it means,
No, I'm not trying to argue.
but this will be what, basically to lay out what the defense, what I would expect is for you to lay out what the defense or defenses that you believe you'll be presenting evidence about will be, to kind of, again, give the jury a roadmap, an idea of what to expect as your witnesses come forward. And then at some point, I don't know whether you will make a decision to testify or not, but we do have to have a conversation on the record about that. So
Yeah.
just give me an idea, if you are going to testify yourself, if you think that would be at the beginning or at the end, so I can gauge when to have that conversation with you.
I don't know for sure yet at this point.
Fair enough. So at some point I'll have that conversation with you though. All right, we'll see everyone at 8:45 tomorrow. Thank you everyone. They're in recess.
Oh yeah, I'm sorry.
Okay. So, I'm gonna go into the morning, because there was, Danny mentioned that there's a bit of, well, I actually went back to it, had to do with the viewing of the, so what happened today is that, if you guys didn't know, the jury went and jury physically went to go watch, see the vehicle, and there was some issues that Mr. Brooks had regarding that. The first part of it, though, was apparently one or two of the jurors had tested positive for COVID, but the jurors and the judge elected to keep moving forward. Of course, Brooks didn't like that.
And so I wanted to make a record. Thank you, juror number 41.
So in here she's asking each juror whether or not they're still willing to move forward with the trial for that day. They all said yes. Brooks doesn't like it because he doesn't get a delay out of it.
I guess in reference to me myself just having the same concern a few weeks ago.
Requests given this information.
Well, I believe that the jury clearly all congregate together.
So here he's still bitching about it,
What
but
I would say is this.
the big part of it is talking about the viewing, the vehicle viewing.
I want you to be advised that you have a right to be at that jury view. Did you hear me
here it
say
is.
that?
Yeah, I mean, you pretty much told me yesterday about, everything that was going on. I didn't agree to or consent to it being, well, I was still confused about why did there even need to be a jury view. That was my whole thing. I don't see the relevancy of it, and I also didn't agree with or consent to having to be part of something that I don't see as relevant.
I appreciate you making a record of that, but did you hear what I said, that you have a right to be present for it? I've ruled that let me back up. There's been a request from the state to have the jury look at the vehicle that was recovered by the police and, of course, is alleged to be the vehicle that was driven through the parade. Did you hear me advise you of that?
Yes, I heard.
All right, so that motion was addressed previously, and I granted the request for that jury view. Did you hear me say that?
I'm informed.
All right, thank you. So with that, you have a right to be present at that jury view. Did you hear me say that?
I'm informed.
And I would like you to be there. I believe it is a piece of evidence. That's why I've drafted jury instruction 152 the way that I did. Did you hear me say that?
I'm informed.
So my question to you then this morning is, do you want to be present at the jury view of the vehicle?
I don't see the reason why I would need to be present.
Well, that's my question to you, though, is do you want to be present for it? You are the accused in this case. You're the person who the state has alleged committed these acts. The jury view will be to view a piece of evidence that frankly can't come into the courtroom due to its size, and the jury's going to be shown that. So do you want to be present at that?
For the record, I'm not a person. I'm a human being.
Oh,
And,
God, I forgot he didn't say that. He says that.
No, I do not consent to or agree to being present at a jury view.
All right, then I'm going to honor his request, but what I am going to do, though, is as part of that process in any event, because it's being done in a secure location, is I have ordered that I want to make a record of what's being done, and I want a visual record of what is being done. And so this jury view is going to take place in the Sally Port of the jail. And precautions are being taken so that the jurors do not know where it's at. It'll look like a garage, right? Anything that says jail within the Sally Port is being covered up. That will be verified before anyone is taken in there. They will be transported to there. I'm not sure if they'll walk or drive because it's very close. But then the sheriff's department, because as the court official, I'm in charge of keeping the record, not keeping the record, I'm in charge of making the record. It's the better way to say it. And I want to make sure that there's a record of what is done for this trial and certainly for any appellate purposes if need be. The sheriff's department, the sheriff's department is obviously charged with the security and safety of a courtroom, including the jurors. And so I have asked the sheriff's department to record. And so there is a camera that will be on.
They
a
uploaded that on Law and Crime Network.
Record what's there before anyone gets there. I've instructed them to take that camera to walk around the vehicle, and while it's recording, to put it back on the tripod. And before the jurors and the court are brought in, once we are brought in, it will also be recorded, and that contemporaneous recording. So that will be as we will walk around the vehicle one time. That will be recorded, and then both of those recordings are going to be made part of the record. Because the second recording is for the record and has the jurors, at this point I'm going to seal it so that at least until the conclusion of the case, given the order that I have regarding the what's referenced as an anonymous or numbered jury. So that will be sealed. But what will be released to the public or be made part of the public record, and so therefore any media request, would be that recording that just shows the vehicle without the jurors in it and without the court. So, and then I plan on also bringing that back to the courtroom while the sheriff's department's going to bring it back, and then we'll show it to you at that time.
I have a question though.
Go ahead.
If I have a right to be present, then I have a right to not be present. How can this take place if I don't agree or consent to being present?
So he's trying to think he could pull a fast one that by not agreeing to be there, he could just cancel the whole thing. That's not how that works.
How can it even still take place without me?
It will take place, sir. I'm just going to honor your request not to be there.
I'm asking a question though. How can it take place without my consent or agreement?
If you don't, it's going to take place.
She even realizes what he's trying to do. That's the moment where she realizes what he's trying to do.
Answer that, sir. So you not going there is not going to prevent it from happening.
My Lord,
but you can forfeit your right to be there by your conduct. And by your conduct, by not answering my question, by saying I don't want to be there and I don't consent to it, you will be forfeiting your right to be present and essentially waiving that.
Doesn't I have to sign something for it to be waived?
But don't you have to require me to do something that I know I'm not going to do to make it all legit? No.
I don't think so in this case.
Well, yesterday you said something about
I know I said that, and I've had some time to think about that further.
I changed my mind.
I don't believe I need to take a full waiver with you signing anything or even agreeing to the waiver.
So why did I have to do that for when my
I'm not going to answer those questions because that
Well,
would be for me to give you an explanation of the law.
no,
I'm
it
just
would
going to
be-
tell you that I'm not going to require a written waiver from you in order to honor your request
True.
to not be at the, or even if I phrase it, your lack of consent to the jury view.
And is that lawful law? Because
Lawful law?
Sir,
Is that lawful
I'm not
law?
going to go through all the law that applies to that.
The way
This is
I-
my ruling. If you disagree with it and ultimately there is a conviction, you can raise that on appeal. But
No.
your lack of consent
No.
is not going to stop the jury view. It's going to happen. It's a piece of evidence that I cannot physically fit in this courtroom. It's too big. There's no way to get it in.
okay, I'm informed of that, but at the same time, if I haven't signed any waiver, how could it be lawful? I haven't given consent or agreement to a jury view. I haven't waived any right. When the whole issue was brought up, on the record yesterday, my first thing that I said was, I don't see the relevancy of why there should even be a jury view.
Well, it's the murder weapon.
That was the whole issue. And yesterday I was told about the, I don't know how you say it, the colloquy or however you say it. I don't know how to pronounce it.
I know
Which
what
was-
I said.
Colloquy.
I'm telling you, I had time to reflect. That was my initial reaction to your statement yesterday, but I've thought about it some more and I'm changing my mind. I don't believe I need to take a full waiver with a colloquy with you and anything in writing. I'm advising you, you have the absolute right to be there. But I'm also advising you that if you choose not to be there, I will honor that request. And I'm not going to force you. I'm not going to direct the sheriff's department to, use any type of force, if you will, or require you or get you there without your consent. You either cooperate with that process or you don't.
The way I interpret the law, though, Your Honor, which the law is designed to be interpreted by the people. The way I
So that's that. The law designed to be interpreted by the people, aka me. So my interpretation of the law stands. That's his fucking logic.
interpret that is, I have the right, or essentially to be there or not to be there, and it still has to be an agreement or consent. That's how I interpret the law.
My ruling on that
Well,
part is
you're wrong.
I disagree with you. You do not need to provide consent for the jury view to happen. Your objection is noted for the record. I'll make a specific finding today that it is relevant to these proceedings, to this trial. There is an allegation that you drove through the Waukesha Christmas Parade on November 21 of 2021, driving a red Ford Escape, killing 6 and injuring dozens more. The relevance is that there is, in addition to the charges, there's an enhancer that has been charged as it relates to the intentional homicide charges and the first-degree recklessly endangering safety, that you committed those acts while using a dangerous weapon. I would direct your attention to the meaning of a dangerous weapon, that the legal definition that was provided to the jurors in the preliminary jury instructions, and that the jury view is related to the evidence that the state is presenting regarding the charges, and specifically the instrumentality that they allege is the dangerous weapon. So there's clear relevance of this vehicle and has evidentiary value. Again, your objection is noted for the record, but I will and am permitting the jury view of the vehicle. With that, I'm going to move on to the jury instruction.
I don't agree or consent to that, Your Honor.
I understand
If
your
I'm
objection
not-
is well noted for the record. I need to keep going though on the pattern and
I'm
jury.
informed that you need to keep going. I'm not trying to stop you from continuing to go.
You are.
I'm merely stating for the record that there are things I do not understand how they're being permitted
Well, maybe you should get a lawyer.
versus the Constitution. I mean, I'm sure you're aware.
What?
under
What?
Article 6,
Article
Chapter
6.
2 about the supremacy clause. That
But
the
the
Constitution is the supreme law of the land.
Okay, and what part of the
how can we
Constitution
disregard-
is being violated
I'm
here?
not disregarding the Constitution.
How?
Here's the thing. I've made my ruling.
You can't even explain it.
Once I've made a ruling, I do expect
Diane,
that
thank
if
you for the membership.
Disagree with it, you will not continue to argue it.
It's not
That
arguing.
we will continue on with
You
it.
are
It's
arguing it.
Your Honor, it's not an argument.
Mr. Brooks, I'm not going to explain further other than what I have done, my ruling. My ruling stands. Now, I'm going to move on to the jury instruction. I gave the parties
May I
2
respectfully
documents.
reject that ruling and take exception to that ruling?
Your objection is noted. I'm
For the
moving
record,
on
may
to
I
jury.
request a legal
to-
and factual basis for your
Mr.
ruling,
Brooks,
Your
please
Honor?
don't interrupt me, okay? I give you an opportunity to raise your objections and to make your legal arguments.
raising
and then I make a
objection now.
ruling, and then you start in on something else. You need to give me your argument all at once. For you to interrupt me afterward is disruptive to me.
It's not
And
disruptive.
it's interrupting and it's disruptive.
It is definitely not
Well,
disruptive.
if that's my view of things, sir, and what I'm putting on the record is that it does disrupt what I'm doing and the flow of what I'm doing and needing to move on, having to interrupt what I'm doing so that I can address that once again. Please, please. I know you may not always agree with my rulings, but I'd ask that you show the courtesy and decorum that is expected of everyone. And once I make a ruling, we're going to move on.
Thank
you. Don't
you.
need to keep objecting because
The
your
one
objection
land.
has already been noted for the record. I'm
For
going to
3
continue.
months.
We're going to look at jury instruction 152.
Well,
I gave the parties 2 documents yesterday. One was the pattern instruction, which I've modified, and then one is the draft of, and Mr. Brooks, please stop. You're continuing to talk over me.
Because you
You're
didn't,
interrupting.
you said I have the right to object, and you didn't let me even get to the objection.
I did, sir.
No, you
okay?
didn't. I was right
Your
in the middle of
objection
it.
comes before
Oh my God.
the ruling, not after. Once I make a ruling, we're moving on.
Okay, he doesn't understand that you don't get to have a back and forth with the judge. The judge made her her determination. Doesn't mean you can continue to have this back and forth. It's over, done with.
You made a ruling before we even finished the conversation, Your Honor. With all due respect,
Brooks,
before
please
we
stop.
even finished,
That's not true. Okay?
you
It's
said
not
I'm going to
true.
make a ruling. As soon as you even started in about
Mr. Brooks, I'm not
having
going
the
to
time to
spend
think.
hours on end making a ruling about a jury view on something I've already decided. All right, so please, I'm asking you to stop. Stop
Nah,
interrupting me.
You can't,
and please
just
listen.
disregard the United States Constitution, which has a
I
supremacy
absolutely
clause.
am not disregarding the
You
United
are.
States
You're
Constitution
not
or the
honoring your oath
Constitution of
office.
the state
Your
of
Honor,
Wisconsin.
are you not a public servant?
Okay,
Shoot,
Mr. Brooks,
shut
you're
this
starting
fucking
to
guy.
cross the line. You've already crossed it, but I want to keep going. I
didn't
want you in
cross
this
any line.
courtroom. But if you keep interrupting me and putting you on notice that you run the risk of being forfeiting your right to be present in this courtroom and continuing in the next courtroom so that I can effectively and without interruption continue with the proceedings this
So again,
morning.
you're holding me in contempt.
She never said that.
Jury instruction 152, has the state had an opportunity to review it?
Is that a judicial determination that I'm being held in contempt?
She never said that.
I agree generally with the court's proposed instruction. I did submit kind of a counter-proposed
Ridiculous.
instruction following much of the language that you had in your version, Your Honor. I just think it's maybe better to refer to this area as a garage instead of a sally port. I don't know that everybody knows what a sally port is unless they work in this industry. And instead of
Definitely do
referring
not
it
go to
as
Urban
the
Dictionary for the
Waukesha
definition of
County
sally
Jail,
port.
I just suggested a garage attached to the Waukesha County Courthouse. I think that is factually accurate and would dispel any concerns about anybody being in custody or reference to a jail setting. I did email my proposed instruction to your clerk and I e-filed it, but I admittedly just did that a few minutes ago. So that's why I emailed it to the clerk, because it's probably not in your queue yet.
All right, why don't we print that off so that Mr. Brooks can review that as well.
Seem to being called that name. What do I need to be reviewing?
The state has submitted an alternate proposal for instruction 152.
And that's referring to this quote-unquote jury view?
Yes.
He's throwing a goddamn tantrum because he didn't get what he wants. He wants contempt because it'll delay the proceedings. That's all it is.
I accept for value in return for value this document. Now, I'd like the record to reflect, I still haven't received my original copies of my filings here this morning with the timestamp.
Let me know when you've had an opportunity to review it if you so choose.
I just stated for the record, I accept for value in return for value the document.
Do you have any position on this state's proposal?
I'm still trying to understand the whole process.
Mr. Brooks, my question to you is, do you have any position on the state's proposed jury instruction? Otherwise, I'm going to rule on their request.
You're going to rule on the request anyway. I got a lot of questions that don't get answered.
Just
I have
so
to rule on
fucking
the request.
snippy.
It's been a proposal filed with the court.
You haven't ruled on subject matter jurisdiction yet.
What
In
a
any
goddamn
event, you have a
child.
position on the jury view, sir.
Yeah, what about subject matter jurisdiction?
What about
Well,
subject
that's
matter
fine, Mr. Brooks. You
jurisdiction?
have a position on
Can
the
I
state's
go over the
proposed-
document, please? Can I do that, Your Honor?
Oh.
Respectfully for the record, may I do that?
Now he wants to read because you already handed it, but you're sitting there throwing a tantrum. Fucking toddler.
You seem like the same thing that was there yesterday.
Oh my god, he does.
There are some changes.
What changes? It's the same document. That was
Reference
was
to
accepted for value
the-
and returned for value yesterday. The same document.
It's not the same. The changes were put on the record verbally by the state. It's taking out reference to Sallyport of the Waukesha County Jail, referring to it simply as a garage attached to the Waukesha County Courthouse. Those would be in the first two paragraphs. I believe the rest is the same.
So it was a couple words changed.
Yeah. And do you have an issue with it?
So it's the same document.
It's words.
Review yesterday. Accepted for value and returned for value yesterday.
All right, then let me ask you this, sir. Do you have a position on the proposed instruction from the state?
It's essentially the same document. What was the significance of the change? What's the significance? Garage, Sallyport. What is the?
He doesn't.
What is it
Okay.
called?
All
State
right.
will put on the record again the basis for the changes you made.
Your Honor, to my way of thinking, it is beneficial to the defendant. It removes any reference to Sallyport, which some may recognize as being part of the Waukesha County Jail. It removes reference to the jail itself. And then in the second sentence, the pattern instruction was worded, and the court followed it. You will be taken to the Sallyport in the custody of the jury bailiffs. I just thought it was better to change that. You will be taken to the garage by the jury
Am I getting
bailiffs.
Comcasted?
Again,
Damn
removing
it.
the use of the word custody
Sorry.
is it's factually true, but it's really irrelevant. And just to be cautious, Your Honor.
With that, sir, do you have any?
I don't fundamentally understand that.
Of course you don't. You're an idiot.
I think everyone's well aware that I'm in custody. So how does the wording change what's already known? Everybody knows that I'm housed in the Waukesha County Jail. How does the wording change what's already known? It's reported on every single day.
They're making the change
As it
for your
has been since the
benefit.
beginning of trial and even before that. So I don't think anyone's not privy to the knowledge of where I'm housed and that I'm in custody.
Thank you, Taylor, for the $9.99.
How does changing the wording change what's already known?
Thank you.
All right.
From my perspective, Of course, when I drafted this yesterday, factually, what I put in there would be accurate because that's where the jury view is going to take place. I think changing the verbiage so that it says a garage attached to the Waukesha County Courthouse takes away any possibility that other law enforcement is condoning what is happening or somehow related to the case. It is true the location was selected due to your custodial status and being able to secure the area for the court, for you, for the jurors, etc. But it's also a controlled environment, I think, a good thing for purposes of the jury view. And so I am going to adopt the draft that was submitted by the state. It still is factually accurate. And from my perspective, again, the importance of this instruction is to tell them what is and what is not evidence, and to instruct them and to not talk during this time. They can't discuss what they see during this time. This instruction will be read while we are still in the courtroom prior to the parties in the court going to the Sally Port for that viewing, and I've already discussed how it will be contemporaneously recorded so that it's part of the record as well.
So if I was there, where will I be at?
My understanding, if you choose to be there, is you will be escorted.
Now he wants to change his mind and be there.
The bailiffs would be with you. You'd be in your suit.
No, where will I be at?
You would. I don't know exactly. That's up to the sheriff's department as to where all the parties are going to stand. Obviously, you would. We're not going to commingle you with the state or the state with jurors or you with the jurors or the court or anything like that. My understanding is we'll have sort of assigned places and that it's only myself who will walk around. And I may not even do that. I have to think about that. But the jurors are the ones who are going to walk around the vehicle one time.
So I don't get to walk around the vehicle?
I can have you do that before the jurors come in. I certainly can have you do that if you would like. I can give the parties that opportunity.
May I add something else, Your Honor? I agree with everything the court said. I also think Mr. Brooks should understand that it will be a fair process. He's not going to be led into the room in shackles in front of the jury. It's my understanding from Captain Dussault, the attorneys for the state, the prosecution team will be in the room. Mr. Brooks will be in the room. We will be in our assigned location. It will be fair. It will match. There will be basically no distinction between how Mr. Brooks appears to the jury versus how we appear to the jury. We will be in there first. If the court's willing to allow him to walk around the car one time to look at it, we have no objection to that. And then the jurors will come in. No one will speak. They will do one lap around the car. They will leave the room, and then the parties will leave the room. That's my understanding, Your Honor.
And I will add to that, because it's been a while since I had some preliminary discussions with the Sheriff's Department on this, that if however many bailiffs, sheriff's deputies are with you, I want the same number with the state, right? And that's what we mean by it will look no different. So each party will be accompanied by deputies.
I have a question to that.
Okay.
How come none of that knowledge of how it would be conducted was discussed with me? I didn't know anything about how the bailiffs would actually do things, how certain things would go. This is my first time hearing this.
Well, we have
So
preliminary.
I don't understand it.
We have preliminary discussions at the time of the request back in August when you still were represented by counsel. And then I had some additional preliminary discussions, if you will, internally with court staff, which included Captain Dussault and someone from the jail to talk about it and the logistics of it. And then, of course, we're having the discussion now, which is again, why there's no jury here now. I wanted to wait until the appropriate time and then make a record of everything.
But don't you
At no
think-
time did I have conversations independently with the state.
Don't
They
you-
had filed a letter at one point because they themselves had, again, my understanding, and Attorney Opera can correct me if I'm wrong, had some discussions with, to see if it was feasible. They had some discussions with Captain Dussault. And Captain Dussault is with the Waukesha County Sheriff's Department. Of course, the Waukesha County Sheriff's Department and the sheriff is statutorily responsible for the security of the campus, security of the courtroom. And so that would be the proper person for any party to have discussions about a piece of evidence such as this.
Person.
But I
Fiction?
did not have any discussions with the state myself. That only happened in the setting of a courtroom or when a letter was received and I reviewed it.
I haven't reviewed that letter or seen it.
Well, you probably had it on you, right?
Don't you think that?
It was specifically addressed at the jury status hearing, at which time he was represented by Attorney Perry and Attorney Keys. It is on file, and it was addressed by this court, many of these details, Your Honor.
All right.
Many of the same
So-
details that's being discussed right now at this moment?
All right, Mr. Brooks, do you have a request as it relates to any of that?
Well, yeah, I'm still trying to understand the whole how
I thought you didn't
how
want to
this
be
is
there.
all working, and then it was a reference to
Dude, I thought you didn't want to be there, so what does it matter, the process? What, you changed your mind? Oh, because it didn't work in delaying in delaying the proceedings or not having it at all? So now you want to be there because it's happening with you or without you? Interesting.
how the shackles would look, or how being shackled or not being shackled. I'm guessing that I can't just walk around freely. With bailiffs, I'm sure there would be some type of shackles.
I will tell them you are not to be shackled visibly for the jury to see.
And what do you mean by visibly,
And-
Your Honor?
So, obviously when you sit in court, you're shackled to a table. They can't see that. I'm not going to have you in belly chains or in leg shackles. You're just going to be escorted. And it will be up to them how they determine.
Well, he may be in leg shackles, Your Honor, if there's a table or some way that they can keep that out of the view of the jury. Just like he is in court. He's shackled in court. He has been for 3 weeks.
Actually, these are
The security has to be left at the discretion of the sheriff's department.
actually these
That
are
we have-
leg shock devices, not shackles.
Sir, the security is up to the sheriff's department. I should be careful not to overstep my bounds on that. And, you know, whatever is done, it should not be viewable or visible to the jury.
And why is that, Your Honor? I don't understand that part. Why is the jury not privileged to see?
So as not to be prejudiced against you. I feel like, okay, this is what I'm trying to think. I think he's trying to make the argument that if the jury are to see him in shackles, they'll have sympathy for him. Like, oh my God, look at what they're doing to this poor prisoner. I think that's what he thinks is going on here.
That is to your benefit.
Shackle.
I'm not going to explain that any further.
I don't understand. I'm just seeking to understand. I don't know.
All right, I need to move on. So unless there's a specific request, other than a statement that
Yeah.
you're making about your lack of understanding, I need to move on with the other topics
There is
I
a
need
specific
to cover.
request. Why do I have to have ankle shocks on my ankles
Oh, never mind. He just wasn't
to
one I'm on in the first
appear
place.
at this jury view thing?
I guess I'm not aware of what you're talking about. So were you advised by the sheriff's department that that would be the case?
Well, the DA just said that I would have the ankle shocks on.
No, shackles, she said.
No, these are not shackles. They're shock device.
Judge, I think perhaps we can move on. I think maybe because this is going to have to occur on a break, the bailiffs can take him down there if Captain Dussault is willing.
show him what it's going to be like, show him how he's going to get there, and he can decide at that point if he wants to be there or not when the jury comes in the room. We're spending a lot of time talking about security and things that are frankly beyond.
He needs one of those Fallout era slave collars.
I object to that. I'm simply trying to.
One of the ones that blow that you can blow up the head if you go way too far.
I'm going to leave the security. I'm not going to make any specific orders. I'm going to backtrack a little bit. I will leave the security of the jury view to the Waukesha County Sheriff's Department. That is their responsibility. And I trust that they will do what needs to be done to maintain the security, no different than what they do here. And in their discretion will determine how best that takes place. And if I need to address anything after that or at that point in time, then it should be brought to my attention. But we are going to move on this morning.
Ooh, we're liking the Running Man. That's also true.
The sheriff.
Yes. So I know, Mr. Brooks, you filed with the court 2 documents. I'm going to take them under advisement.
No, it's one document. It's one. It was 2 papers, but it's one document.
Oh, all right. Thank you for that clarification. It's 1 filing, 2 papers, just front side, entitled Alleged Defendant Jurisdictional Challenge and Mandatory Judicial Notice by Affidavit. It references the case caption, the case number. I will simply take it under advisement, and I'll review it later. And if I believe it needs to further be addressed, I will do that. But it's my understanding, sir, that you are requesting the original back. Is that true?
Yes.
So normally, just so you know, when documents are filed with the court, we
oh my God, I
original
this part
until it's scanned in and it's audited. And
he's wanting for
because
he keeps bitching about not getting his original filings back, and it's very irritating to hear this.
Under the statute, once it's e-filed or into the electronic filing system in the electronic case, I believe we just destroy the documents at that point. So I don't have an issue giving you back the original, but it needs to run the normal course. My clerk needs to scan it in. I've advised you of this previously, but in the courtroom, we don't have the time stamp. We just have the date stamp. I will state for the record that you provided this. It was right away at the beginning of the morning, so at 8:30 a.m. is when it was filed with the court, so that will be on the record. And then at some point today, when we're on a break, my clerk can scan it in and then provide the original back to you, and then I'll have the electronic copy to review and address as I deem appropriate. Here you go, Madam Clerk.
I want to say to that, too, in reference to that, I actually said on record numerous times that I wanted the original copies of all my filings. I've actually said that 3 times on the record. This would be the 4th time. Every filing that
I'm going to give it back to you, sir, but I'm not required to by law.
Well, I'm just saying on record that I've asked for that numerous times.
Your statement's noted for the record. All right.
So would I be able to get all the original copies of all my filings?
I'm not going to address that any further, sir, because I am not the official keeper of the record. As to what was filed this morning, as a courtesy, we will provide you back with the original once it's scanned and it's in my electronic file.
I was told that you make the decision if I can get the original copy.
And I just made a determination you could have the original back of this.
Can I have the originals for all my filings?
I'm not going to address that right now, sir. I don't have time, frankly, to look through everything that you filed to determine whether we've given you originals or not. In the future,
I have the copies. I don't have the originals.
Oh my God.
All right, I'm going to move on.
I have them here.
This is taking up valuable time with the jury. We need to keep going.
Is that a judicial determination, Your Honor, that I can't get an answer to something?
I don't believe there's any other preliminary issues we need to address unless the parties have anything from the state.
Just very briefly, Your Honor, to advise the court, I have 4 witnesses here that I believe are very brief records custodian type witnesses on some video evidence. I'm hoping my direct should take 5 to 10 minutes for each of them. And then I have 2 police officers who will be testifying. There will be some physical evidence involved when those officers testify.
All right, I'm gonna go move on to probably the last part of the trial that I think I did notice the tail end. This is a detective who I can't recall what his main purpose was, but it was involved with the crime scene, obviously, but I can't remember.
So how did you ultimately come to that decision?
Says he didn't understand and
Of the investigation is to the 20.
objections are noted, overruled.
Do you believe this map is an accurate summary of the travel and whereabouts of?
Danny's right. Accident reconstruction.
On the evening.
That's what it was.
November 21.
Objection, speculative, and I'm not consent to being called that name.
Your objections are noted. They are overruled. The witness.
What, Archer?
Yes.
All right, thank you, Detective. I don't have any other questions.
Any cross-exam for this witness, sir?
Yep.
All right, thank you. Begin when you're ready.
So, Officer Rowe, you repeatedly referred to the alleged defendant's name. How did you come into that information?
Based on the entirety of the investigation.
And when did you come into the knowledge of the alleged defendant's name?
I don't remember.
When did your part of the investigation start?
After he drove the SUV through the parade, I was called at home to come in and help the departments with the investigation.
And just so we clear for the record, is the jury asking you questions or?
I'm sorry, I did not. Repeat your question. Please.
Well, I was referring to
What?
when I ask a question, he turns towards the jury as if they're the ones asking the question.
That's not a question, Your Honor.
It is a question.
We did ask a question about that.
Yes.
Do that to that extent the witness may answer.
I'm here to present the case to the jury.
So, I follow that fundamentally. But for the sake of making sure you hear the questions right, wouldn't it be fair to say that you should pay attention to the questions being answered, or being asked, rather?
Assumes the fact, not an evidence.
Sustained as to the form of the question. Please rephrase.
Wouldn't it make sense to focus on the questions so you can hear them clearly?
Objection argumentative still assumes the fact, not an evidence.
Sustained.
You made reference to you being here to present the case to the jury.
You're
So
talking.
is that the reason why you decided to testify?
I think my brother could probably confirm that he's trained to do this when he's on trial. You're speaking to the jury because it's the jury who was supposed
Were you able to hear my question clearly?
is going to make the decision.
Were you able to hear my question clearly?
Objection argumentative, Your Honor.
Sustained. Next question, please. Or rephrase the previous question to the one that was asked just now.
What was not understood about the question that you were asked?
Objection argumentative.
Brown.
Argue.
Sustained as to the form of the question. Please rephrase.
What wasn't clear about what I was asking?
Same objection, Your Honor.
Grounds.
The objection is sustained. Let's go back and ask the question that he says he didn't understand and rephrase it, please. Or move on. Your choice.
Was your sole reason for testifying here today?
Objection relevance.
Let's let Mr. Brooks get the question out. Go ahead.
Apologize, I thought that was it.
He's so fucking mad. Thank
Are
you,
you
Anonymous, for the
testifying
$2
today?
tip.
Strictly to prove your case to the jury.
Objection, misstatement of his testimony.
Grounds that that's what he said.
No, dumbass. He said present the case to the jury, not prove. He said present.
Sustained as to the form of the question, misstates the prior testimony.
That's what he said.
No, he didn't.
So why did you decide to testify here today?
Objection, that's a legally inaccurate question, Your Honor.
Please rephrase the question. I'm sustaining the question asked as to the form of the question.
I don't know how I'm supposed to rephrase that. Without having the same form of the question. That helps.
I'll rule if there's an objection, but ask a question, please.
Did you seek to testify here today in this matter?
No.
No.
So how did you ultimately come to that decision?
Objection, that's a misstatement, Your Honor. It was not his decision.
Sustained as to the form of the question assumes a fact, not an evidence.
Were you subpoenaed?
Yeah.
Yes.
Do you recall by whom you were subpoenaed to testify?
District Attorney Sue Opper from the Waukesha County District Attorney's Office.
And at that time you were subpoenaed, you decided to testify.
I don't believe it's my decision.
God damn it.
Well, it would be fair to say that you didn't have to show up, right? Is that fair to say?
A subpoena is a requirement to show up. That's the point of a subpoena.
No, I had to show up.
But would it be fair to say that you could have chosen not to?
No, it would not be fair to say that.
Oh my God. Jesus. Oh Lord. Oh man. All right.
Exhibit 131 that was shown to you. Have you seen that video footage before today?
Yes, I have.
Do you recall who showed it to you before today?
I don't recall who showed it to me.
Would it be fair to say you've seen it multiple times before today?
Yes, I've seen it a number of times.
And do you recall when you were first shown that video?
Not off the top of my head.
Was it the same day of the incident, the days following, sometime after?
I don't recall when I saw the video the first time.
Thank you all of you for being here today, by the way. Please hit that like button if you can.
And what about Exhibit 130? Had you seen that video footage before today?
Objection, Your Honor. 130 is the map.
Or the map? Had you seen the map before today? I don't really think it's...
Just for the record, I'll sustain the objection just because it referenced the wrong number, but I believe you rephrased. So go ahead, the witness may answer.
Can you ask the question again, please?
Had you seen the map of Exhibit 130 before today?
Yes, I have.
Multiple times as well?
Yes, numerous times.
Any idea why you viewed it so many times, multiple times?
Unsure.
Were you able to obtain any more information upon seeing the map numerous times that you didn't obtained when first seeing the map?
No.
So it would be fair to say you pretty much knew what the map was detailing each and every time you saw it.
Yes.
All right, I think I'm gonna move along since we're running out of time.
Objection, relevancy.
Overruled, the witness may answer.
It does not.
This is the state patrol who also worked on the vehicle. Basically, he's testifying that there was no issues with the vehicle before the incident, so that it basically cuts out any argument that he could make that the vehicle was, the brakes were malfunctioning or the throttle was permanently pressed down. Anything to show that it was a mechanical failure that caused or contributed to the incident, rather than Brooks being a fucking shithead.
Finally, sir, you had talked about actually coolant or some type of water. I wasn't sure if you're talking about the water pump or the radiator. Do you know what was leaking, if anything?
Objection. Asked and answered during cross.
Overruled, the witness may answer. It's redirect.
Yes, so water pump, water coolant, it's all interchangeable as far as the cooling system for the engine goes. And the coolant system was low at the time of inspection and had been leaking, but from where I do not know.
And again, does that control the steering,
No,
the braking,
no,
the acceleration?
no.
Finally, sir, you had talked about on cross-examination the presence of the high beams being on during the daylight. Do you recall that line of questioning?
Yes,
Specifically, you had indicated that sometimes the state patrol uses their high beams during the day. What was that for?
Objection. That was answered.
Overruled, the witness may answer. It's redirect.
to increase visibility.
Is that of any assistance if a vehicle is coming up behind people?
Objection. Speculative.
Based on his training and experience, I will allow him to answer.
No.
Thank you. Nothing further.
All right, thank you. You may step down. I will take that. Thank you, sir. And
Why he's so fucking mad?
I'll excuse the jury for an afternoon break. It's just about 3:06. We'll take about 15 minutes. I'll rise for the jury. You can be seated. Mr. Brooks, I know the last thing you said, I heard you say that's hilarious. What were you referring to?
I was referring to, like, are you serious? Some of the same things that I ask on when it's my time to question the witness can be overruled, but when the same thing is done and I object, it's nothing. It's just thrown. It's just thrown to the side. I just think that's funny.
Well, sir, I don't find it funny, number one. Number two,
you're not in my position either.
The court rules on the objections at the time that the objections are made. I know, and I wanted to address this briefly. You can have a seat. you had questioned during the testimony of this witness Exhibit 83, because I believe what you were saying is, and you can tell me if I'm wrong on this, the copy of the report you have does not have an exhibit sticker on it.
It don't.
Right. And
Okay.
You want to see it?
I don't doubt that your copy does not have an exhibit sticker, because at the time the report was provided to you, and I'll have the state correct me if I'm wrong on this, it would have been provided through the course of discovery. I'd also note that on April, I believe 22nd of 2022, the state
Close to my
filed a
birthday.
notice of expert naming Inspector Ryan Schultz as an expert witness, and indicated that he would testify consistent with his report. And then I directed your attention to the statutes in the rules of evidence dealing with expert testimony.
Oh, God.
specifically
This is where she teaches him.
907.02 through 907.07. That is why I didn't stop during the testimony to have a discussion outside the presence of the jury, because at that point, the objection to not having an exhibit sticker on your report is not, would not prevent the court from receiving the exhibit once the proper foundation was laid, which in my opinion it was. And the fact that your document didn't have that specific exhibit sticker doesn't diminish the fact that I know from your cross-examination you were referring to the report. At times you referred to it by page number. It was clear from your questioning that you had reviewed it. I would just note two examples. You asked some questions regarding visibility and the impact of the high beams. That was one example. And then secondly, questioning him about the ball joint and whether it needed attention.
So basically, she's putting on the record that it didn't really make a difference whether or not the sticker was on the evidence.
The only thing that came from the report was from page 9, when I was trying to get clarity about why it said worn tie rod.
Oh, and you actually questioned the witness about the different tire and what that would mean. So I thought three good areas of cross-examination that you covered. As far as the other issues I think that you might have when there's redirect, I'm not going to explain what redirect is, sir, but again, for my position, there's direct examination, there's cross-examination. The state or any witness, any party that calls a witness always has the opportunity to ask the direct exam questions and then redirect based upon
It's not even listening
during cross-examination. Sometimes that does mean there's some repetition.
Again, he's a child.
I didn't see anything through the redirect of this witness that I thought was improper. So I just wanted to make a record of that. I am going to caution you, sir.
Do you understand what I was saying?
But you, during multiple times during the questioning of that witness, you were mumbling under your breath. You say disparaging remarks toward the court, toward the witness, or toward the process.
So if it was disparaging, what did I say?
Sir, you say things like it's not fair, or you make noises that suggest like you're disgusted with the ruling that is made.
So you're assuming what I mean by that, and when did I say it
Mr. Brooks,
wasn't
I'm
fair?
just making a record because
Yeah, but
it's important
you're making an
that
incorrect record.
it's important that you demonstrate courtesy and decorum through these proceedings, and that you give respect to the witnesses who are testifying in the process.
Did the witness feel disrespected? Did the witness say anything about feeling disrespected?
Mr. Brooks, I'm not going to engage in this
I don't think
back
you did.
and forth with you because, first of all, it's a mischaracterization of my observations, number one. And
Yeah,
number
but your
two, it's
observations
my
are
job.
incorrect.
It's my job to ensure that under 906.11 that there's the effective presentation, and I'll just refer you to that once again. I'll read it into the record.
You don't need to read it.
Under
You don't need to
906.
read it. Just make sure that you make a correct
The judge shall exercise
Don't
reasonable
lie on the
control over the mode and order of interrogating witnesses and presenting evidence
it's gonna
so as
get
to do
addressed
all of
every
the
time.
following. Make the interrogation and presentation
Every time.
effective for the ascertainment of truth, avoid needless consumption of time, protect witnesses from harassment or undue embarrassment. Sub 2 talks about the scope of cross-examination. Sub 3 talks about leading questions and when leading questions may be used to develop the witness's testimony. So with that, we'll take our break. I'll start the 15 minutes. It's 3:13. We are in recess. Thank you. Go ahead.
I did actually take note of when the court overruled one of Mr. Brooks' objections. His
don't
response
consent to being
was,
called that name,
"Stop
Your Honor."
trying to be slick."
Yeah, I did say that.
So,
All right.
just for the record, I thought that that was very disrespectful.
Thank you. I would agree.
Judge, can we discuss scheduling at some point as well, either now or on the
When we
return?
come back.
Why wasn't that addressed right when it happened?
Honestly, Mr. Brooks, I'm really trying hard
Because
not to highlight
that's the
your
definition of
misconduct
trying to be slick.
during the trial. I'm trying my best here to
I don't see
frankly
that.
minimize
I don't
pointing
see
those
it.
things out to the jury and instead
The
pointing
level of
them
back
out
talk.
outside the presence of the jury. You may have noticed I've even started to say I'd remind the jurors that the comments of the parties or the attorneys are not evidence, so as to cast a broad brush and not simply highlight your conduct.
I haven't noticed anything, and I don't
But all right, we're in
refer
recess.
to what
Thank you.
conduct
It's
you're referring
3:14.
to. If you're gonna be biased, then somebody else.
You just cut some off. I'm gonna stop it there. He does do another blow up after this, but it's at the very beginning of the stream. Like he does it right at the beginning of the stream, so we actually saw it all live. So if you want to check that out, you can check it out at the beginning of the stream, because he does almost get thrown out again. But I'm gonna stop it there, guys. It's almost 8 o'clock. I gotta go eat something, and I actually still have some more work to do before getting to the office tomorrow. There might be a handful of streams over the weekend. I don't know if any. I don't know if I'm going to have time for it. I'm actually going down to Dallas. I'm going down to Dallas to meet my parents as well as Danny. We're just going to have some and hang out with my brother and be there for the full long weekend. And but I'll be back on, and on Wednesday I think I should be back. But obviously I'm gonna try and pay attention as much as I can to the trial, because obviously the state is expected to rest tomorrow, and Brooks is supposed to start his defense tomorrow. So, and we all know it's gonna be a shit show. So, all right, guys, thank you very much. Have a good one, and I'll see you next time. Later.
Hey, question.